Baker Commodities, Inc. That's case number 6223-1. This is for a modification for an order for abatement. And Madam Clerk, we have some exhibits.
Recording in progress.
Okay. And Madam Clerk.
Madam Chair, would you like to start over because they just turned on the recorder a few seconds ago?
Per my clerk over here, she's telling me I don't need to do that. So.
Okay.
That was for the Spanish channel.
Madam Clerk, did you also receive exhibits from Baker?
I have not received them. How did they have them?
Madam Chair, we held on to them. We submitted a letter. Madam Chair, we held on to them. We submitted a letter, a cover letter to our revised proposed findings and decision on June 6th. Counsel for the district has objected that that constitutes an unauthorized brief. And so we disagree, obviously, but we didn't want to circulate those exhibits until.
Okay, all right. Well, let me backtrack a little bit then. You, sir, are here on behalf of Baker.
I'm sorry.
And your name, please.
Yes, my name is George Giganis from DLA Piper on behalf of Baker Commodities. With me is my colleague, Isabella Neal. And just two brief ministerial notes.
Wait, just a second. And on behalf of the district?
Daphne Sue on behalf of the executive officer.
And Nick Dwyer, also on behalf of the executive officer.
Okay, all right. Now, Mr. Giganis.
Just a moment, Madam Chair.
Yes, ma'am.
We do need to swear in the interpreter since they will be interpreting.
Oh, okay. All right. Well, I normally do that after I do exhibits. So are they out there? Okay. Are you going to have witnesses today?
Not unless the board requests it.
Okay. And Ms. Sue?
No, it was my understanding that that part of the hearing is over.
Okay. All right. So we'll just swear in then the interpreters.
Madam Chair, just a question before we swear in. We're doing closing comments, correct? Just want to clarify, we're not rehearing any other matter.
We're not rehearing, however, we have given them time and opportunity to work together to hopefully come to an agreeable conclusion.
But true, but we're not going back to take any witnesses, et cetera, because when we left off.
No, what
Okay,
this is
very
all
well.
about is just
Okay.
interpreting for the Spanish speakers who are listening in.
Okay, no problem. Thank
Okay.
you.
Please raise your right hand. And do you swear in the penalty of perjury that you will be translating what you hear from both sides directly to the listeners and from English to Spanish and Spanish to English?
I do.
Thank you so much.
Chair, we have a second interpreter. I'll call him in.
Oh, okay. We'll get that when she comes back in, hopefully. She comes back in with them. Yeah. Okay, I need the other interpreter in here also. Okay, I need you to state your name and spell it for her, please.
Jaderer, Morrone, Morrone.
And you too, ma'am.
Elba Bárcena, ELBA Bárcena, BARCENA.
Okay, and can you please raise your right hand? And under penalty of perjury, you will be telling the truth, the whole truth, and you will be translating it from English to Spanish and Spanish to English. Thank you very much, sir. And ma'am. Okay. Okay, so let's go ahead then and mark, Madam Clerk, where did we leave off?
For the petitioner, we're at number 40, that's 40. And for the respondent, we're at double HH, Henry.
Okay. All right, so the proposed findings and decision. We will be marking HH, is that correct, Madam Chair, Madam Clerk?
Is that the proposed findings?
Yes.
From the respondent?
It's from, no, that's from the petitioner.
From the petitioner?
It's gonna be 40. All right, that'll be 40. Now, the one that's, so we have two up here, one that shows the differences. Actually, I both show them as differences. One is the proposed. I have two copies. Is it two copies of the same thing or is it two different items? Well, both of mine have edits on them.
There's a comparison document that compared.
Oh, yes, yes, yes. Okay,
In the two, and there's also.
okay. And these are coming from the,
Petitioner.
yes. Okay. So we can then find, let's see, that would be number, or that would be HH. That's begun. Okay, I have the proposed findings as 40. Proposed findings as 40. Okay, so this will be 41, 42.
Madam Chair,
Okay,
the petitioner is the district.
yes.
Right, okay.
Yeah, got that, know that.
Anything from the district.
Okay. And we don't have anything from Baker yet.
No. They also sent, in dispute is the letter, but they also had a proposed finding and decision document from the,
You still have those?
yeah.
Yeah, so he has,
I mean, we got the email, so.
yeah, but that's not hard copy here in front of us. Okay, so how many exhibits do you have?
Well, we have the proposed findings and decisions,
Mhm.
modified proposed findings and decisions. And then there's a cover letter on top of that that describes the changes and our view of the hearing.
Okay, and you have copies for all of us?
We do.
Okay, why don't you give those to the clerk?
Okay.
And we'll mark that starting with HH.
Chair, we had sent objections to the clerk regarding the purported cover letter because per hearing board rule 5E, the hearing board didn't set a schedule for closing briefs.
Okay,
Sorry. All right, so the cover letter that you have from DLA Piper, is that the one you're in objection to?
Correct. We don't believe that it should be filed and considered.
Well, according to our hearing board rules, I would agree with you.
Madam Chair, if I may. The purpose of this letter was not as a closing brief, but was given the sort of unique situation here, we were continuing the hearing to have the parties try to work something out. The purpose was to explain the changes that Baker was making in compromise and to explain why those changes were supported and the issues in contention should be, how they should be decided.
Well, I understand that. According to our hearing board rules, we do need to follow those rules. So what I'm going to do is just put that aside and I'm going to let you verbalize.
Certainly,
Okay? All
certainly.
right,
Thank
so
you.
then that will become, your proposed findings and decisions will then become HH, correct, Madam Clerk?
that is correct.
Okay. All right, with that. Now, since we allowed Baker to go first last time, are you still in agreement with that? Okay, so Mr., please tell me how to pronounce your name again, Jiginis?
actually very close, Madam Chair. It's Jiggins, but I'll respond to anything.
Goodness, okay, good enough. All right, so you're going to be presenting what you feel are the changes that you felt needed to be made. And before you do this, I'm hoping that there was some good conversation and some good back and forth so that we have a document in front of us that everybody can live with. So we'll see.
We'll see. I think there are still some points in contention, and I'm hoping to give the hearing board an organized overview of what's agreed and what's left. Very briefly beforehand, just two ministerial points. One, my colleague Isabella Neal must step out at 10 o'clock to attend a call. And so apologies in advance for that. And then secondly, we had a bit of a snafu with a court reporter this morning. So we may end up having a court reporter who attends. And if we could take a brief recess to allow that person to set up, we would appreciate it.
Not a problem.
Okay, thank you. So hearing board members, thank you, first of all, for your continued time and attention to this matter. We very much appreciate it. The mandate from the board was to go back, find areas to compromise, and at a minimum, narrow the gap on the issues that remain in dispute. We believe we've done that. Baker has made meaningful concessions in compromise and has heard what the hearing board questions, comments, and concerns were. Unfortunately, we believe that the district's position has changed, but changed in the opposite direction, and that there are actually some new restrictions or new provisions that the district is seeking here that push the district's proposal further away from compromise. And I'll go through those issues as briefly as possible and as organized way as possible. The first difference between what the hearing board proposed, what the district proposes and what Baker proposes is one that has always existed, and that is how this modified order should terminate. The district proposes that the order should terminate after the district itself issues the permanent total enclosure extension permit, essentially putting the termination of this hearing board's order in the district's discretion unilaterally. Baker proposes that the hearing board's order terminates upon the completion and operation of the 3 enclosures that Baker is building over the 3 areas that we discussed at our last hearing, which would allow the order to terminate on a clear date that's a date certain. And tied to Baker's compliance. The second issue in contention is a new one, although it is one that the parties briefly discussed, and that is that the district now wants a demonstration of Baker's equipment within the PTE before Baker is allowed to start up its collection or transloading activity. The equipment for that activity is not yet, it has to be leased or purchased, so it's not yet there. And so Baker could not conduct a demonstration for the district before today. But Baker's view is that, Baker has the expertise to conduct this operation. It knows what it can do inside the inside the PTE, and no demonstration is needed to show that it can do this work. But that is, a smaller issue that's in contention here. The third issue is what happens if the district rejects or denies extensions of either the 3 enclosures or permits for either the 3 enclosures or for the PTE extension. And the district's proposal is that if the 3 enclosure permits are not granted within 120 days of this order, or if the district rejects them or denies them, the applications, that Baker must cease operating on the interim basis immediately. And Baker's view is that this would allow the district essentially to ignore the hearing board's decisions regarding the manner and mode of operation if the district decided they were to impose conditions within the construction permits that were different from what the hearing board has either allowed or authorized. And so given that this is a hearing board order and that the interim operation is pursuant to the hearing board's conditions, Baker believes that that if the district and Baker are working out the permits for the enclosures, that the district should not be able to sort of unilaterally stop Baker's operations on that basis. The fourth issue, and there are several of these, but I will get through them and you'll see that there actually are agreements. So we're getting there. The fourth issue is the one that we discussed extensively at the last hearing, which is the maximum load within the permanent total enclosure during this interim period. And this one, I would like to point out, Baker has reduced in compromise the proposed maximum load from 200,000 pounds within the PTE at one time to 175,000 pounds within the PTE. And I mean, as we discussed at our prior meeting, the 200,000 pound limit itself was quite conservative, designed to be conservative and designed to have, cushion and safeguard built in. So 175,000 pounds is a concession. It's an attempt to get things agreed and finished, but it's even more conservative than the prior. The district, on the other hand, has not made any compromise and has stayed at 60,000 pounds as its maximum load. I would point out that, and again, without steering too far into advocacy here, we do not believe that the district presented evidence with foundation based on experience that this 60,000 pound limit had a reason or basis behind it. The next point of contention is a new one. There was a lot of discussion at the hearing previously about how the pit would be used. There was some information that was relatively new to the district about how the screws were to be removed, and those large steel plates were going to be welded into the bottom of the pit to make a smooth surface for the collection of material. And the district has now suggested a new condition that would be that the pit cannot be used at all until the screw conveyor mechanisms are permitted and put into place. There's no justification for that. There's no explanation for that in what the district proposes. There was no discussion of that previously, and it's not a workable condition, nor is it justified based on the evidence. The sixth point of contention is the receiving hours issue. And here the district has provided some compromise. They've suggested rather than 8 a.m. to 8 p.m., they have nudged the opening time down to 6 a.m. So it would be 6 a.m. to 8 p.m. according to the district's proposal. And Baker continues to make the point that while certainly the regular times of delivery would be within those operating hours, it is always possible that there would be an emergency need, or that there would be breakdowns, that there would be traffic, that there would be customer needs that arise in an unanticipated way that would require some flexibility within that time period. And so we continue to need some flexibility, and to point out that the alternative would be for trucks to essentially be waiting on the side of the road until they were allowed to enter the facility, which is not to anyone's benefit. The seventh point is, I think, some happy news. Here, the district has proposed a maximum of 20 truckloads to come into the facility in one day. And Baker can agree to that. If that's what the limit that the district wishes to put, we don't believe that there's any reasonable anticipation that Baker would have more than 20 truckloads. And so in the spirit of trying to get this done, we can agree to that. The eighth point is about overnight storage. We talked about this as well last week. And this one is a very important and essentially a non-starter in the sense that it would be impossible to operate under the condition that the district is seeking to impose. And that is that the district wants all of the material to leave the facility by 9 p.m. every day. And that is not possible to operate as a collection center doing that. We had extensive discussion about how all of the material will be within the permanent total enclosure, that we cannot operate, or that Baker cannot operate if it's required to clear all material out on a daily basis, and that Baker certainly is committed to not storing material in the enclosure long term, and that would be contrary to any incentive whatsoever to operate this business. And so it's not a real risk. But the district continues to insist on a 9 p.m. Clear out. And that, as I said, would not be workable. The next point is about pit cleaning. Obviously, we've agreed, we've made the concession that Baker will clean the pit on a weekly basis under the conditions that we all discussed last time. Baker remains committed to doing that. It's unclear what the district's position is on this because they have, as I mentioned earlier, proposed that the pit not be used at all, which is new. Then the next batch of conditions has to do with what we discussed regarding Rule 415. So the parties had agreed that rather than argue about whether Rule 415 applies to this operation or not, we would simply propose that explicitly list out those conditions from Rule 415 that the district believes are important. And the happy news here is that largely, as I had thought, largely we are in agreement with a couple of important exceptions. So we're in agreement that all incoming transportation will be covered. We are in agreement that the vehicles and equipment within the extension, the skip loader and so forth, will be washed down. The district has proposed on a daily basis, and Baker, although that is a significant operational burden, Baker has agreed that they will do that. We are agreed about drums and containers being washed down. That's not a large issue. The district has proposed that the whole receiving area, the inside of the receiving area, be washed down on Mondays, Thursdays, and Saturdays. And while Baker had proposed weekly, again, as a concession to get this done, Baker will agree to do that. And then the floor drains wash down, that's in Rule 415E. I think it's 11. That is also always been agreed that the parties, that Baker will maintain the floor drains in a clean state. The issues that are in contention, or really the issue that is in contention, is regarding the delivery of raw rendering materials into the PTE within 60 minutes. What Rule 415E says is that 415E2 says that that raw rendering materials will be delivered within the permanent total enclosure or a covered container within 60 minutes. And while, again, we don't believe that Rule 415E applies, Baker has committed very clearly in its SOPs to have all raw rendering material be under covered tarped trucks unless it's in the receiving area, the permanent total enclosure. And that is what the district has previously accepted. And you heard testimony from Mr. Paolo Longoni regarding the district having agreed that tarped trucks constituted 415E covered containers. There's no reason they should not. They're obviously covered. It serves the same function, and Baker is committed to doing that. So we need that. There's no way that Baker can guarantee that all materials will be within the PTE within 60 minutes of arrival, given the way that the trucks have to come in and out. However, Baker can and will and has committed that all material will stay covered within the facility at all times, whether it's in the PTE or in a covered container, meaning a tarped truck outside the PTE. I would point out here that the alternative, again, is that materials sit in a truck on the side of the road somewhere until they can come into the facility to be put into the PTE within 60 minutes, which is not to anyone's benefit. So that's the main issue with what we could call 415E-like provisions. Last issue is odor detection. The district has proposed odor detection response protocols that go far beyond anything that even Rule 415 would require of a rendering facility. Baker has, in its original and its modified proposal, very detailed odor response SOPs, an odor response plan, which is something that if 415 applied, would be required, and Baker has done that. That odor response plan, we believe, is more than adequate and addresses any issues with odors that rise to a level that a rule like Rule 415 would address. What the district proposes is draconian and not workable. It goes, again, beyond what Rule 415 would require. It says that any odor that's detected at the property line, any odor at all, requires a response within half an hour, and that the district then, that triggers a process where the district can then shut down the entire operation if it decides that that's what it wants, outside of the nuisance odor rules and regulations that would normally apply to the district in any other operation. It's not workable because there are odors in Vernon that have nothing to do with Baker. That should be pretty self-evident. There is a trash company that collects refuse across the street from Baker. There is a wastewater processing facility that's right down the street.
Objection, this wasn't in the evidence.
I think that
If it's not in evidence, then we can't discuss it.
okay, in a court, I mean, the hearing board could take the equivalent of judicial notice of what operations are around the facility, but if the hearing board is not inclined to do that, that's fine. I can just say that the area of Vernon where Baker operates is an area where there are industrial processes that generate odors. The standard for an operation, whether it's Baker's or anyone else's, is not and has never been that there are no odors. The standard is that odors are minimized and that they don't rise, that no odor can rise to a nuisance level. And there are rules for that the district has. There are procedures for that the district has, and they should apply to Baker as they apply to every other facility in Vernon. So those are the issues. And I know that this has been a bit laborious, but I hope that I've demonstrated that Baker has made meaningful concessions and meaningful compromise here. And we've gone as far as the company should reasonably be required to go by this hearing board. And we're hoping for a decision from the board that reflects that.
Thank you, sir. Okay, Ms. Sue?
Good morning. We are here today because the hearing board found Baker in ongoing violation of district rules, and Baker is still subject to an abatement order. Baker is still playing games. It filed a closing brief against the hearing board's explicit rules. It did not provide an engineering witness a witness to testify to the calculations of how many pounds of raw rendering material can readily be stored in enclosure. Consider how often in your experience, in even routine matters, facilities provide an engineering witness to testify so that the district, the public, and most importantly, the hearing board can fully understand the facility's proposed operations. Baker was not forthcoming to the district regarding its plans to operate. The district engineer testified he was not aware that Baker was intending on covering the rollers, removing and covering the rollers in the pit. That plan was a total shock. Such significant modifications require a permit to construct, but no such application had been submitted. Baker is attempting to circumvent the careful evaluation that is part of the permitting process. Baker had made a decision several months ago to cover the rollers, to remove and cover the rollers. Baker sandbagged the district by keeping its plans to itself until it filed its exhibits. Given that Baker has the propensity to delay giving information to the district, we ask that they have 3 working days or within the timeframe requested by the district, whichever is later, to provide additional information on its permit applications. That is condition 8B. Also, as further incentive to provide information in a timely fashion, we ask for a condition that they stop collections if the permit to construct the 3 wastewater-related enclosures have not been issued within 120 days of the order. It has been Baker that has been not acting in good faith, and we want to ensure that they provide information in a timely manner to process these permits. Terminating the order when a permit to construct is issued for the extension is important to ensure Baker still has operating conditions for its collections. Now let's turn to the remaining issues before the hearing board. What conditions are required? The parties agree on allowing Baker to begin collections. We disagree on the proposed conditions for collections during the term of the abatement order. The district's proposed conditions are aimed at reducing potential odors. Baker is saying, trust us. But their standard operating procedures have provisions that are not enforceable or are irrelevant. They provide set hours to receive material, but then they say they may receive material after hours. The 400,000 pound capacity stated in the standard operating procedure after completion of the extension of the raw material receiving area oversteps the purpose of the abatement order. That is a potential permitting question and should not be decided at this juncture. Mr. Pearman raised a concern regarding stating a maximum capacity post-abatement order, yet Baker still tries to sneak in this provision. The 400,000 pound provision should be removed. They say there would be no long-term storage of material at the facility, but they do not define long-term. It may be true that fresher material has a higher monetary value, so they have an incentive to move materials out of the enclosure. Mr. Andreoli testified their motivation is, quote, making as much money as they can, end quote. Let that sink in. Baker is under an abatement order because they broke the rules. While we would like to be optimistic that they have turned over a new leaf, trust must be earned. We ask that they provide a demonstration prior to starting operations. Not prior to the abatement order, a modified abatement order, prior to starting operations. It was troubling that when asked about how the equipment would be used, given that there are beams in the way, as shown in Exhibit 17, Mr. Andreoli testified that the skip loader would be pushing the material into the pit after the truck has left. So it makes me wonder, is there enough room to maneuver the loading equipment when a truck is inside the enclosure? We believe 60,000 pounds, 30 tons, at a time in the enclosure is appropriate. 60,000 pounds is what Baker said can be stored on the slab in their current PTE prior to the extension. Could take a look at Exhibit GG, the current PTE prior to extension for that diagram. We ask that they be prohibited from using the pit in this interim period, given that they have no permit to construct to modify their pit. Further, Baker has not shown that they can manage a higher volume, particularly when using a skip loader with a front shovel or loading claw. Previously, when Baker was processing the raw materials on site, Baker would be using a screw conveyor. Mr. Andrioli didn't have an answer to my question as to the depth of the pit or how deep a skip loader with a claw could reach. What was the height of the skip loader? The claw. Air curtains may be insufficient to manage potential odors. Allowing air curtains for the enclosure was based on the facility using a conveyor to move material and being able to process the material on site. The operational process of movement of material was understood. Air curtains are not an air pollution control device. The enclosure does not have negative air pressure. When a pedestrian door is open, or if there are small unsealed openings, potential odors can escape. We propose materials within an enclosure within 1 hour. Baker testified that I was confident they can move materials quickly, so it's unclear why they are backtracking now. Now, back to the 60,000 pounds. Please keep in mind, we are not limiting how much they can collect, just how much they can store. We are not limiting their throughput. Further, 60,000 pounds is more than one truckload. Baker's witness testified that each truck leaving the facility carries about 45,000 pounds. 60,000 pounds give them some additional capacity so that they can have more material dropped off before a truck comes, so that truck does not have to come immediately to pick up. Baker is asking for 175,000 limit on the enclosure. This is almost 88 tons. Now, this number and their other so-called conditions are primarily based on business needs and logistics. Baker's transloading standard operating procedure says it typically receives material, quote, between 6 a.m. and 10 p.m., but may also receive hard material after hours, end quote. So in essence, under the terms of their proposed order, they can receive material 24 hours a day. I asked who was responsible for keeping track of the pound limit. Mr. Andrioli testified, the environmental specialist. Yet, he said this person works from 8 to 5 or 7 to 4 p.m. So who is responsible after hours? It appears Baker's management has not thought its plan through. We also asked that no material be stored overnight at the facility. This would ensure that material leaves the facility and does not degrade and become more odorous over time. This would allow for the enclosure to be washed down. In an effort to compromise, but still mindful of potential odors, we asked for a wash down 3 times a week. Almost every hearing board member asked very general questions on cleaning procedures and rigorous washdown operations. The inability to address the hearing board members' concerns should not be rewarded. Even their revised proposed order is written so their washdown provisions would be difficult, if not impossible, to enforce. Baker wrote, "The raw material enclosure pit shall be washed down once per week. In performing these washdowns, Baker is not required to remove all animal matter from the pit, but must clean the pit to the extent reasonably practicable." Now, how and what is Baker washing down if material is still in the pit? Would it be possible worsening potential odors by spraying water where there is animal matter? Would water be able to drain if there is animal matter? They haven't even trained all their relevant employees on new procedures. If the hearing board is so inclined to issue a revised order, we would like to add a condition to prohibit the start of collections until all employees have been trained on procedures and the revised abatement order. That provision is currently not in our revised proposed order, but we request that it be added. Where we thought it was possible, we attempted to address Baker's concerns. As Mr. Jiggins said, we originally had proposed that Baker shall comply with Rule 415E, including the washdown provision, and that given Baker's objections, we deleted the reference and instead listed similar specific provisions along with others under Condition 12, odor best management practices. To allow Baker more flexibility in our revised proposed order, we increased the hours that Baker may receive materials from 8 a.m. to 8 p.m. to 6 a.m. to 8 p.m. We also increased the number of deliveries Baker may receive from 15 to 20, and we're glad that Baker has agreed to the 20 deliveries. It cannot be lost on the hearing board that board member Ali's question on whether the district's rendering requirements are the most restrictive. Mr. Andrioli affirmed to his knowledge the districts were the most restrictive. That same mindset was used by South Coast AQMD. We are not penalizing Baker. We are seeking reasonable limits that are consistent with holding the line on odor minimization. Trust must be earned. We heard one public comment from Communities for a Better Environment. The speaker said, there has to be firm times of entry and exit. CBE doesn't care about business flexibility at this point. It's either follow the rules and keep odors at a minimum or cease operations. That was the public comment. Baker is requesting to store up to 175 pounds in the enclosure, but Baker has shown they are not prepared. Baker hasn't trained all the staff that will be doing the work. Their environmental specialist, who is responsible for Baker's limits, leaves at 5 p.m. It doesn't appear that there's a lot of room for loading equipment to maneuver when a truck is inside the enclosure. We believe 60,000 pounds is appropriate at the outset so that they can show they are able to operate without any potential odor issues and adhere to the conditions. And as for the odor detection provision that Mr. Jiggins referred to, it says Baker shall determine the odor source as soon as possible and shall undertake remedial measures immediately and no later than 30 minutes to correct the problem. So if the odor was not coming from Baker, then clearly they would not need to take remedial measures. Our proposed order has a status and potential modification hearing so that the hearing board has an opportunity to reevaluate the condition, including interim and limit, potentially increasing it if it shows that Baker is capable based on Baker's performance. Thank you.
Thank you, Ms. Sue. We had talked about entertaining some questions. And I'm wondering if board members want to allow them to ask each other some questions right now, or do we want to dive into this ourselves first? What is the pleasure of the board?
I do have questions to clarify some of the
I
conditions
do too.
of the both the petition and the respondents. Is that what you're talking about? Or?
Well, I want to give everybody the most opportunity to present what they, what their opinion is, and I shouldn't say just opinion, on how they feel that, whether Baker feels that the district is acting unjustly, or whether the district feels that they are doing their due diligence, and what we also have questions in regards to that. And I would like to let them ask questions of each other first, unless the board would like to ask questions first. So I'm asking you, board members, if you feel you want to ask your questions, or do you want to let them ask questions first and kind of clarify a few things? Do you either one of you feel that there has to be any clarification in what you presented this morning?
I don't feel that there's a need. I'm ready for the hearing board to deliberate.
Okay, all right. Mr. Chicanis?
I certainly have some thoughts and responses to Ms. Sue's presentation, which in some cases was hard to swallow. But I will, at the hearing board's pleasure, I will either have those responses or hold them.
Okay, let me say this to begin with. I really don't want to hear or appreciate one calling the other a bad actor. I think we're all trying to find a solution here without being degrading or being in any way impolite. So that being said, that's what I want both sides to please adhere to, number one. And I think that the board members here, we've been going over this quite a bit, and time after time, there's always something new that comes out of this. But I'm hoping that we will be able to find some type of resolution here. And so I'm going to go ahead and go to my board members first. And Mr. Balagaplan, you want to start?
So it's okay to ask questions of either parties, the attorneys, for clarification.
I think that's why they're here, yeah.
No objections from, so.
Because we need to find out, we need to
Okay.
see where
All
we're
right.
going here.
I made my own comparison table, so I'll go through that, and then I think there were a couple which I didn't think were, anyway. Let me ask with the main, I think now that I've heard, main issue is if the permit to construct for the PTE has not, the engineer has not issued it yet, correct? We heard in the declaration and the testimony from both the engineer and the inspector that they felt that there needs to be a negative air with a control to a scrubber. And if the engineer is going to issue the permit with that condition, that is going to be or we're not sure how the engineer or what the engineer is going to do with that permit, whether he's going to issue a requirement to vent that to a scrubber and all for the PTBE to be under negative air. His declaration and both the inspector was very emphatic on his declaration that they have no control because they don't have negative air, not going to control. And Mr. Kandari's declaration also said the same thing, there's no control. Now, and I know you can't speak per se for the engineer, but if let's per se, if the engineer is saying, going to issue a permit and say, you need to have it under negative air and go into a control system, that changes the whole dynamics of this thing. And I can see the concern that was raised by the party, that is beyond what the board is ordering, as conditions in this order, and that will supersede everything else.
I believe the question that was testified to is whether or not air currents were considered air pollution control, and the answer was it was not. And I think there was additional question regarding what would be considered air pollution control. And in terms of permitting, I don't know what the permit will require in terms of air pollution control, if any. That's a permitting question. And also if Baker disagrees with permit conditions, there is also always the permit appeal process where the parties will come before the hearing board. So, and right now, as you can see in our conditions, there is no requirement for air pollution control. I was just pointing out in my closing statement that air curtains are not air pollution control, and that was what the testimony showed.
However, their declaration by the inspector, if you look at the declaration, I can bring it up and hang on, let me see if I can get the exact Mr. Paulo Longuni. And this is and this is on page 3, line, starting 20. I'm concerned with potential orders if thousands of pounds of raw rendering material are allowed to be stored indefinitely in enclosure that lacks air conditioning, it's not refrigerated, it's not connected to a scrubber, it's not connected to arbor. The PT is only equipped with the air curtain to two large revolving door. That's his concern, And then the engineer also said, currently, there's no air pollution control that's used at the PTE. It's not air conditioned refrigerated. Raw materials are likely to become odorous the longer they're left at ambient temperature. And, they roll up doors and equipped with air curtain. So, and if that's the thinking that there's no air pollution control and air curtains are not, I think according to the staff report, it's secondary pollution control. They define in the staff report. It's not primary. It's not. It prevents the air from going out. It's not reducing, eliminating the air pollution. It's just a mechanism to make sure the foul air, when the doors are open for up to 5 minutes, it doesn't rush out. So with the air curtains, it prevents it from going out, and that was allowed in the existing rule 415, and that's what was in the permit. So. And if you look at the staff report on page 272, you'll see a reference to the air curtain and what they say, the secondary air control. So my issue is, and I personally, and I think I mentioned it before, is all of these issues that are ongoing, problems with odors and stuff, can be resolved, in my opinion anyway, if there is an air pollution control, if it's under negative air, if it's going to a scrubber. Now, but I cannot mandate that because, however, and my rationale for saying that is also based on the staff report. We've seen Baker's New York facility has that, according to the staff report. They have it under negative air, and there are a number of other facilities throughout the country that have done the same, including Darling, which is here, that they have and the engineer testified that they issued the permit for it to be under negative air going to a control. I think. So my question is, again, I'll go back. I'll do my testimony later. If the engineer is saying, okay, I'm going to issue the permit to construct and require, because there's no control, and that's the thinking, both the engineer and the inspector. I'm going to, if the permit to construct says you have to have negative air and a scrubber, you're saying if that permit is issued that way, then they can appeal that condition and come before the board again to appeal that, if that is issued in that manner.
I don't know if it's clear that that's what the declarations are saying. It's just pointing out what is currently at the enclosure. That was the point, just laying out facts, what is at the enclosures, air curtains, and what is not at the enclosure. I don't believe it's meant to speak to what will be required in the future. My point in saying they can always appeal is with any permit, if there's conditions in dispute, the party has an ability to appeal before the hearing board and ask for a modification, change the permit. That's all I meant to say. And I believe these declarations are just laying out what is currently at the facility when you're considering what should be the limits, what should be the conditions.
May I just make a comment here? So I think the council made a point about a follow-up status conference, which is something that we had discussed. And if that's not reflected in our revised proposed order, that's fine. That was an oversight, and we're fine with having a follow-up status conference. The purpose of the interim period is to be, for everyone outside of Baker, to be certain that the Baker's process works, and we're confident that it will work. The issue of whether at that point in time an air scrubber would be an appropriate condition in the permit under the standards that give the district's engineer the discretion to make the various determinations is something that I think will be importantly informed by the experience during this interim period, which is another way of viewing this as to why it is important for Baker to allow Baker to operate in the manner that it's requesting so that we know. I mean, again, Baker is confident. We believe the evidence lines up. We believe that all of the questions have been answered with respect to these operations, and that this interim period will provide important and valuable information, not just to the hearing board, but also to the district's engineer, who, when operating in good faith, which he always will do, he will see that these operations are appropriate the way they are. Ultimately, the decision of whether an air scrubber is required, I agree with council that if that is a permit condition that the district engineer seeks, and that Baker agrees with, then great. If Baker does not agree with it, then there is an appeal process there. And this interim period will provide significant and important information for that process.
The engineer in his declaration, or I think during testimony, said is 2 to 4 weeks away from issuing the permit for the PTE. Would you be prepared to wait until the permit is issued before doing anything?
We can't. I mean, so Baker has been under the OA for, I believe, over a year now, and it is a dire situation. And the reason we filed the request for modification when we did was because while we were attempting as much as possible to make progress with the district on a stipulated OA, it got to a point where the situation was critical. And so we have not seen the draft permit from the engineer for the PTE extension, and Baker cannot wait for that draft permit. But again, the operations during this interim period that the hearing board allows will be important points of information we would think, for the district engineer to consider.
So sometimes, I mean, as part of the permitting process, I mean, if the engineer determines upfront, this is the requirement, and the permit to construct has to be issued before you actually do the work in the area. So without the permit to construct, you actually cannot do any construction in the PTE until the permit is issued. Whichever way the engineer is going to issue the permit. That's, so you're asking for operation before even the permit is issued. Correct?
Before the extension construction permit is issued.
Yeah, and you're only talking about the extension, not the existing enclosure.
Correct.
Okay.
As part of the extension, the screw conveyor is also part of that application. So it is kind of that screw conveyor within the existing enclosure is still part of their extension application. So it's all connected. They'd have to change how they're operating their current PTE for what they're proposing.
So I think what council is saying is that there will be, as a part of the PTE extension, there will be a screw conveyor that is constructed that takes material from the pit into, as was described previously, into the trucks. And that is correct. But that's the point of the interim operations, is to be able to operate as a collection or transloading facility while the extension is being permitted and constructed.
Can you do the construction inside the PTE while you're receiving material?
Yes.
Without, having the doors open and people coming in and out for the construction?
Yes, absolutely. And that's a point that we have discussed in detail with the district and its engineer. The PT extension can essentially be constructed around the front of the existing PTE. And then once the extension is complete, that will operate as the end of the PTE.
Okay. So let me then, the issue of, let me ask the district, the reason for the demo in loading and unloading, what exactly is it what the engineer wants and the inspector wants to observe before they issue the the permit?
That is not what I say. Staff would like to observe the operations. We had concerns regarding how the trucks and all the equipment will be moving inside the pit. I think it would give the opportunity for Baker to work out any kinks prior to receiving material. So that is the purpose of demonstration, making sure that the loading and unloading equipment can move in the enclosure, and also if there's a truck inside, that the loading equipment can move inside the enclosure.
So to do that, they have to bring material. They have to.
They don't have to bring the material. They could do a dry run without material at the facility.
And
It could potentially be an empty truck with equipment and show us how the loading equipment can move while the truck is inside.
okay, all right. So that's the purpose of the demo.
To make sure that that Baker can indeed move its equipment around the truck. Yes.
Given the pit area with the large columns around the whole pit, like how is the swing arm from this equipment going to come up, swing over to the truck? Is it going to back up? How is that process actually going to work? That's the demonstration that engineering would like to see, and enforcement to see. Is it realistic for Baker to be able to move the amount of material that they're proposing?
Without any material present. You're saying it's just a truck coming in, simulating dropping off material, but no material, no operation to pick up the material because there's no material. How will they know whether you can pick it up or do it without, it's just whether the truck can maneuver.
You could still show the arm moving into the virtual pile and putting it into the truck. So I think that it is still beneficial even without material there. Oftentimes in processes, you would do a dry run before you bring all the material in. So that's all that we're asking for, a demonstration. We do not want to hold things up. As you can see, it's in the conditions because we weren't going to hold up the issuance of the abatement order before the demonstration, but we did want to see a demonstration before they start operations to make sure that Baker is indeed prepared for everything. They could mark off where the pile would be. They can have a truck in there. They can show the motion of the movement of the equipment and the movement of the loading claw into the virtual pile and into the truck.
Can I get your objection? I know you had some objection to that.
Just a response,
Okay.
if at the board's pleasure, if you'd like to hear it.
Sure.
So I believe that we established through the evidence that Baker knows its operations well. Baker is confident that this process will work. They know what's in the PTE. They're quite familiar with the equipment. The equipment's not there yet because we aren't authorized to conduct this operations. Businesses don't, as the board knows, don't purchase or contract for equipment before they know they're allowed to do the operation. Based on the tenor of the district's comments today, I think the board can understand that the concern is that this is not a demonstration to confirm what Baker already knows, which is that this equipment fits and that this equipment can operate. It's a demonstration to seek to find new ways to develop impediments or restrictions. Already, the district has said they don't want the pit used at all. This is new. This is not something that was discussed at our prior hearing. So why do they want a demonstration of material or of equipment operating with a pit that they don't want used at all?
Okay, let me ask, Mr. The pit. The last hearing we talked about the pit and how they will be putting plates on the pit and they'll use the pit area. Why has the decision made not to allow that in this?
As you heard from the district's witness, it was a complete surprise when we learned that they were going to remove the rollers and install these plates. And typically with such significant changes, there would be a permit to construct and an evaluation. There was no application for a permit to construct to make these changes. So given that, and given the amount that Baker said that it could be put on the slab, we believe that 60,000 pounds is appropriate. We were surprised. The district, you heard the testimony total shock that that was what they were going to do.
No, I agree. That was, it appears that was the first time the engineers said, but can you point to me a rule that says that they cannot do that, which is a violation of a permit requirement that that they have to get a permit to remove the screw and put a plate on?
Well, as I said, significant changes to their permit of total enclosure, and we believe that they need a permit to construct to make those changes.
Okay, but you, all right, is there a specific rule you can cite?
Well, Rule 203 requires permits. And also just please keep in mind, a hearing board in abatement order procedures can't go beyond rules too, in its conditions.
Okay, all right, so theoretically, let's say there's a demo and you see the demo and they can show in the demo, maybe their claws can go extend into the pit. Would, pit area, would that be a demonstration that they could do that and remove material from the pit?
I don't want to speculate, and also as you see from the way that our conditions are drafted, we are not trying to hold up collections. The demonstration could occur the day before they actually start operations, start collections, but we're still holding firm right now as to our 60,000 pounds. So they could get the equipment the day before, have a demonstration, next day start collections at whatever limit that the hearing board will have.
Okay, let me get some clarification on your understanding of the 60,000 pound. You allow it, I think their proposal was initially 15 truckloads a day. The district is increased to 20. Each truckload is about 60,000 pounds. So how's the flow? I mean, they're bringing it in 10, let's say 500,000 pounds. And they, each time that they dump the material, that it should be removed. Otherwise, there will be period where will be accumulation. So when you say 60,000 pounds, but you're allowing 20 loads a day, how does that work?
The testimony was that each departing truck can hold about 45,000 pounds. Our proposed limit is 60,000 pounds on the slab. That gives them some additional capacity so that a truck does not have to pick up immediately. How they do their scheduling and logistics, that's up to Baker. But we do believe that there is additional capacity, so it's not as though once a delivery is dropped that they have to immediately pick up. It's 60,000 pounds is our suggested amount on the slab. 45,000 pounds was the testimony regarding each truck that would be leaving the facility.
Do you want to add anything to that? Logistically, I'm trying to figure out how that would work if you're allowing that many truckload and then limiting to 60,000 pounds.
The answer is it would not work, sir. The concession of, as the board member pointed out, Baker had proposed 15,000 truckloads, or 15 truckloads per day. The district's concession to 20 is essentially an empty concession. There's no way that you can conduct an operation that has 20 trucks coming in per day, or 15, where the one-time maximum limit within an enclosure is 60,000 pounds. Each truck, a truck leaving the facility can carry roughly 50,000 pounds, but there's a sort of safety cushion that's put there. So you estimate about 45,000 pounds. And the amount of trucks that you would need that would be to be available to exit the facility and go to its ultimate destination of a rendering facility at one time is one reason why the logistics of that low of a limit simply don't work. And I would point out that, what council said is that the district's position right now is 60,000 pounds. I mean, we have given Baker has given every concession it can regarding the poundage limits. We're not playing games. They need the poundage to make this operation viable, to keep their employees working, and to be able to take this material to rendering facilities where it desperately needs to go. This isn't a bargaining chip type of situation for us. But we would like to know if 60,000 pounds is the district's current position, I mean, what concession will the district make on that point, if any, or should it just go to the hearing board to make that decision, which perhaps it should?
Let me move on, again, on the flexibility, why they hard, I mean, I think we heard testimony that sometimes deliveries trucks may not be available, there could be a breakdown on trucks, and there's material there. So the hard time, I think the concession now 6 to 8 p.m. and then at 9 p.m. it should be completely clean. Why that rigid timeline and not offer some flexibility? Because they may have, like it was pointed out in testimony, pick up at different times, different needs, from customers, and it may have to be a 24-hour operation as long as they are controlling. I'll just say controlling orders. Why the restriction on the time?
We do want to make sure that there is turnover of the material and also the ability to wash down. In Baker's proposed conditions, they said no long-term storage, but they don't define long-term. In their wash down provisions, they say they don't need to remove all the raw material. We do not understand how you could have a wash down without removing all the material. We have expanded the number of hours from 8 a.m. to 8 p.m. to 6 a.m. to 8 p.m. You heard testimony, well, not testimony, you heard public comment where they want firm hours of entry and exit. I think the public is very concerned with starting collections operations. We are also concerned, and we also want a status hearing and modification hearing. If everything is going well, everything is going smoothly, I think at that time, the hearing board can potentially increase capacity. Or if things are not going well and we see that there's a lot of issues, potentially the hearing board will stop collections or decrease capacity. I think the status hearing and modification hearing will be a time for us to regroup and reconsider the conditions.
Let me see. The requirement on the 120 days, if the permit is not issued, normally the burden's the other way around. Rule 210 says the district has certain timelines to issue the permit, not the other way around. So if the district doesn't issue 128 days, then you cannot do that. So the engineer could get busy, vacation, whatever, and maybe, whatever the reason is, and they take 120 days. And if they are not subject to a timeline to issue in a timely manner, and then you penalize the respondent for that, that seems somewhat unfair, because look at Rule 210. There's specific timelines after when the application is deemed complete, when the permit is to be issued by the district. So why the other way? It seems to look.
We have concerns about receiving information from Baker in a timely manner to process the permit applications. You saw how surprised engineering was that they were going to remove the rollers and put on plates. You could see that there is difficulty in getting information from Baker. Therefore, we think that 120 days is appropriate enough time for engineering to evaluate information and process the permit application, and also for EPA to have its time. And as I said before, and I'm leaning on this, there is a modification hearing proposed. And at that time, if, let's say, both parties believe, okay, we need additional time to evaluate and provide information, we could also reevaluate that 120 days. But right now, the way that things are going, how transparent Baker is, we would like that extra incentive for Baker to be giving information to the district in a timely manner.
I mean, there is mechanism. Again, I'll point to Rule 210 to send out AI letter and then to reject the application if the information is not received. I'm just concerned about the timeline. That is, if you want to receive information a certain period, but this is saying that the permit is not issued within 120 days. That seems, if the engineer, drags his feet, not intentionally, but, other priorities, then it penalizes the facility.
May I make a
Yeah.
comment here? We absolutely agree with the concern and with the burden shifting point that the board member has made. We've heard from council several times about these concerns with Baker providing information and with transparency, and I need to make a comment here. What we actually heard from the witness who's providing the competent evidence rather than council's argument is not that Baker is delaying providing information. Those questions were directly asked to Mr. Kondar. And what he said was there are a lot of parties that require coordination. And so sometimes things take time. And I would encourage the board, if they have any concerns or questions about that, to consider 2 points. One, the actual testimony, which is in the court reporter's transcript. Two, and this is where I need to put myself on the line a little bit here. I absolutely insist that my clients are transparent with their regulators. It is critically important. The district is the regulator for Baker. They will be the regulator for Baker. They will always need to have a good, constructive, collaborative relationship with that regulator. So the suggestion that Baker, that my client, is being anything but transparent in attempting to get its operations restarted and to keep its employees employed is very difficult for me to hear. I obviously do not control everything in this situation, but I can assure this board that when we leave here today, Baker's mandate and Baker's intention will be to be as transparent, as prompt, and as forthcoming with information that the district requests or requires as possible. The issue about the plates, I'm sorry, about the plates and the screws, it is absolutely not in Baker's interests to have sandbagged or hidden any information about the removal of screws and putting plates in that pit. To the extent that that information wasn't communicated, perhaps there was an oversight. But to assign motives to that makes no sense. It's a solution that Baker would have been happy for the district to understand if they knew that the district hadn't understood it before. Thank you.
Okay, and that was my follow-up, because he was totally surprised, Mr. Kandahar, that plate, that why wasn't that, communicated to him before? Because in his declaration, he's, okay, so I think you sort of explained that maybe it was unintentional, but it was missed. Okay, let me see. We did hear the requirement now, within 60 minutes, they have to take it into the PTE. And that's kind of new also. But if it's under TARP, and let's say, logistically, there may be reasons why they have to wait until something is cleared out before the trucks can move in. There could be multiple trucks coming in and waiting, to get in to dump the load and so forth. Why that additional, the new restriction on that it should be in within 60 minutes if the truck is already tarped and there's no potentially exposure, odors from there.
Baker appeared confident in how quickly it can move materials, so we were basing it on that. And if the hearing board believes that tarping a truck is sufficient, we would be okay with that.
Okay. Odor detection. That's, as you know, it's very subjective. And you're requiring Baker to, what is the odor? Is that based on a complaint received? Is it based on Baker doing due diligence, going out to the perimeter? How do you envision that odor detection occurring, and response to that? And let's take keeping in mind there may be other sources of odors potentially from in the neighborhood. So if you can answer that.
So the condition says if an odor is detected at or beyond the property line of the facility by South Coast AQMD personnel and or site staff, Baker shall determine the odor sources as soon as possible and shall undertake remedial measures immediately and no later than 30 minutes to correct the problem. So just based on the condition, if there is an odor detected, Baker shall make efforts to determine where this odor is coming from. And if it is possible that an odor might be from another facility, and in that case, there would be no remedial measures taken. But if it is determined to be on site, then Baker would need to take remedial measures.
So according to, thank you for clarifying. So it is the inspector then who is then telling Baker, hey, I'm detecting it, because it says an odor detected at or beyond
It says,
by South Coast AQMD personnel. So it's an inspector
it says and or site staff. So it's either,
or their staff, their staff. But let's take so an inspector gets a complaint hypothetically, and he goes to Baker's site and he detects odor. And is that when you envision this trigger happening where they have to take these measures?
well, either the personnel or site staff would need to detect the odor at or beyond the property line.
Okay, let's say the inspector does get an odor complaint. He goes to the site, he detects odor, you know, and we heard, and in fact, in the staff report also says, sometimes you cannot always say where the source is, but let's say, again, they strongly feel it is Baker. It's coming from Baker. So then the steps are, they inform Baker, hey, you need to find out where the source is, let's say, and let's say they are fugitives, you know, and remedial measures, because, you know, and they are not able to pinpoint because there's fugitive emissions, because from the PTE, as we know, and I'll say because there's no negative air and no control, I mean, no, we're not going to scrubber, they could be from vents and from holes or from openings and so forth. What are they supposed to do then? If the district is allowing them to, you know, issuing the permit with no requirement for negative air or odor control, what are they supposed to do, let's say, in that situation?
So once again, this condition is just part of the abatement order. It's not related to what the ultimate permit may or may not be. So in that case, Baker will have to determine the odor source. Potentially, it might be, let's say, closing the door, the pedestrian door. There's a lot of, it depends on the facts and circumstances, what steps Baker would need to take. It depends on what they find.
So then it says it detected, then the remedial measure, which it's not defined, requested by AQMD personnel. So the AQMD personnel will say what measures they have to take, including but not limiting receive or additional material for collection or removal of existing material within 3 hours. And let's say if there are trucks sitting there, how do you handle that? What remedial measures that will be requested by AQMD personnel?
And I said it will depend on what is found, what is the odor source. So,
okay. So here this, and we're not talking about so we're talking about the PT area basically, right? And the receiving of the material, storing of the material, and the transloading. We're not talking about the other, could it be other wastewater or treatment areas also?
The provision here is written broadly, could potentially, like you mentioned, potentially could be another odor concern elsewhere, another source of odor on their property.
Right. So if let's say, hypothetically, again, it's wastewater or something, there's a breakdown that's causing the odor, unrelated, because they're three distinct, I mean, there's a distinct operation for the trap grease versus the transloading. Why should it affect the transloading in that case?
We are not saying that it should.
But it says you should stop taking.
No, it says including but not limited to. It doesn't mean that that is the remedy. We're just laying out possible remedies. It doesn't say that that definitely is what needs to happen. We just want to be transparent about what measures may be required, but we're not saying that it must be required.
Okay. Is that your understanding? Is that clear as what the requirements are?
No, board member, the council said that the provision is written broadly. That is very true. And I would say that there are times when the council has objected to Baker's use of what council would call broad terms in other places. Here, this essentially gives the district license to shut down this operation at any point whenever they decide that there is odor anywhere at the border of the facility. And that is not what any rule requires, whether it's Rule 415 for rendering operations or the nuisance odor provisions. That's simply not what is required or allowed. On the other hand, there's a detailed odor response plan appended to Baker's proposal. That is a odor response plan that would meet the strictures of whether it's Rule 415 or elsewise. That does have specific provisions required to be taken in the line of BMPs when odors are detected, even when there are unknown odors or a general complaint. And so what Baker would say is that that odor response plan was written carefully and specifically with input from environmental compliance specialists, and that should be sufficient, given it is the standard for other operations.
So you're saying don't shut down the operation, but follow the procedure that is outlined in the odor mitigation plan?
Yes, sir.
Okay.
But how many more questions do you have, Mr. Balak?
I get a few more, but I'll wait until other board members have any.
Well,
Oh, taking a break. Oh, okay. All right. I think it's a good time for a break,
Yeah.
but thank you.
Let's go ahead then and take a 15-minute break and come back and we will continue the questions.
Thank you.
Everybody good to go? All right, you can start the recording again automatically. Did you want to finish up, Mr. Balagopuan?
Yes, Mr. Gizinus, if I may, I think the district indicated that there was no definition of what is long-term. Can you give some kind of definition for long-term?
Yes, sir. And I don't recall specifically, but I believe there was some testimony about this. First of all, there's no intention to keep material any longer than absolutely necessary to turn it over, but I believe it was 72 out of 3 days was the sort of maximum time that we believe that turnover would take.
But there's no possibility of tracking that because waste comes in, they sort of get commingled and all that stuff, right?
That's correct, sir.
So 72 hours or whatever.
The point was to try to put some more specificity around that because the district had asked for it. And the flexibility is the key issue. And certainly, as I mentioned before, having all material out by 9 p.m. on a daily basis is not workable and would render the operation undoable.
So using your definition of 72 hours, how is that workable in a practical sense? How can you verify if an inspector say, hey, this material was there, been there less than 72 hours or more?
Well, you have records of the poundage that's coming in and records of the poundage that's leaving, so you know on a gross basis how long the net turnover takes. But as to particular pieces of material in any situation, it's difficult to make that determination. But what we're saying is that the maximum amount of time that we would anticipate any material being there would be 72 hours, again, within the PTE, at most. So the point is, I mean, I guess the broader point is this. There are many regulations in many areas of law, including in the district's own rules, that do require some amount of flexibility or interpretation. Words like practical or reasonable, those are all words that we do see in regulatory issues. The idea that there's no specific limit there does not mean that Baker will somehow ignore that rule, or ignore that restriction, which is why we spent a good amount of time describing why it would be against Baker's interests and everyone else's for Baker to store material in that PTE any longer than it absolutely had to. So there is some permissibility for some flexibility in these types of situations.
Yeah, I got no further questions this time.
Okay.
Thanks.
I do have some questions, and I want to actually reference example GG, which is the aerial view of Baker's facility, in reference to the impossibility, really, of odors staying within the property borders of the facility, and knowing that city is known for having pretty bad odors coming out of it. Having lived downwind of it growing up, we always smelled it on a bad day. And my grandmother's house is probably maybe a mile away from that top arrow. So there's a lot of effect that the residential people have had there and have had to live with for many years. But we all knew that it didn't come from one source. It had to have come from the sources that were there. And if I'm correct, I remember seeing somewhere on the news that there's only a population there of like 200 people, because everything else is industrial, or it is similar types of slaughterhouses, et cetera, et cetera. So at least I am aware of that. So I wanted to call that up, though. You can see that on the map that there are many facilities there. You don't know exactly what they are, but they're not very far apart. They're pretty compressed. And then the residential is just to the north and east of there. So in that case, my other question also had to do with the 60 pounds. Now, I believe in testimony, it was stated that there's one other competitor, only one other type, similar type of business in the South Coast AQMD. Is that correct, Ms. Sue?
I believe there was testimony regarding another rendering
Yeah, one
facility.
other. Okay, so my question then becomes, what's their limit? What are they doing? Do we know?
I can't testify as to that.
I would like to know that in reference to competitiveness, because if we're asking this company to do more than another company who's already operating, I would say that that's not fair competition. But since we don't know that still to me is a question. Also, in reference to the environmental specialist, when I questioned Baker in reference to this, there was no explanation of what type of training that environmental specialist would have or would be subjected to, either through one of the community college courses that they have regarding hazmat and other types of material. Because I don't think that you can just put the hat of an environmental specialist on a regular employee and expect them to be as specific as I think the district is wanting them to be. And I would really like to see somebody that has got some training. I understand that the hours that were given are either 8 to 5 or 7 to 4. But as a business, I also recognize the fact there are going to be emergencies. And how do we answer that? Do we let them have maybe one day a quarter or one day a month? I mean, what makes sense for that type of business to have a person there who's qualified, better qualified than just putting a hat on them, has some training, and is going to work those additional hours? I think that really is needed here. Let's see, I also had a question in regards to, also it was my question, what long-term meant. And it was stated that it's getting critical for Baker. Specifically in what way? Is it in the reference of doing business and keeping in business, or is it also technical? I would like an answer to that for sure. Did you want to go ahead and start with that?
Yes, Madam Chair. Starting with that question, when I say it's critical for Baker, I mean that the operation, as you can imagine, is sustaining millions of dollars of losses since the beginning of the OA, has kept on the vast majority of its employees, and will need to begin to make significant changes in that respect if we cannot get operations started in the near term. There are also issues related to retaining customers and routes. Obviously, there's a lot of loyalty built up with Baker's customers that is put under a lot of strain when they are out of business and unable to collect or transport raw material to their facility in Vernon, and they lose competitive positioning. They lose customer goodwill and loyalty on a daily basis. At some point, that becomes non-recoverable.
Mm-hmm. Okay. Also, I had a question in regards to the pit. When a testimony was given regarding the plates and the screws that needed to be moved, I understood it as that action taking place for quite a while. How long has that been in that type of operation? Because it didn't sound like it was new.
So the screws have not been removed and the plates have not been welded into place yet. There's the plates, as I think were depicted in one of our exhibits, are sitting waiting for that to happen. how long I think that has been the plan for quite some time. And of course, Baker, to the extent that that wasn't communicated previously, that was an oversight, and it would only benefit Baker to have that plan communicated earlier. So how long that would take, I need to ask Mr. Andrioli how long it will take to remove those screws and put the plates in and weld them. But I don't think that's a very long period of time, a matter of days.
And Ms. Sue, I reiterate again to me why you think that there should not be a pit at all.
We have concerns regarding washing the pit. We have concerns regarding putting plates in without a permit to construct and also removing the rollers. So right now, based on how much material can be removed from in a reasonable amount of time, and also what Baker represented can fit on the slab, that's 60,000 pounds.
So if they were to apply for a permit that included that, would that be sufficient or not?
I would have to talk to the permitting engineer. Typically, you are not allowed to make modifications until you receive the permit to construct.
And you have not received the permit to construct?
We haven't even
obviously.
received an application.
Mr. Giganis, do you have any idea when that will be?
So I don't believe that Rule 203 or any other rule requires a permit for the screws to be removed and the plates to be put down. To the extent that either this board or Baker, in collaboration with the district, determines that there should be a permit for that, on Baker's side, that would be very easy to put such an application together. What the district does with such a permit, if it is required at all, is not for me to say, and would be a sort of a concern.
Well, we're not looking at redoing a rule or creating a rule. We're looking at what would go into that permit to construct, right?
If there were a permit required to construct, to remove the screws and put plates down, that should be a very simple process to do. And as long as the district is not using that permit to impose unrelated or additional conditions, then it's simply a process of explaining these are the screws that are going to come out, these are the plates that are going to get put down. And that shouldn't be an issue. I would point out that the board itself, as the council has pointed out many times, has the authority here to impose different types of conditions and modes of operation, and would suggest that this would be a situation for that.
And it's doable.
It is.
Okay. I understand that staff wants to observe the loading and unloading to see how it's going to work out logistically. Do you have a objection to that?
If that's what the board would like to happen, we don't have an objection. We have concerns about, whether everyone will agree to what's clearly possible within that PTE, but we don't have an objection if the board deems that necessary.
Okay, thank you. That's all I had for now. Mr. Pearman?
Well, thank you. There's a lot of complications still in these orders. Even though you've done a great job of trying to close the gap, there's still like a dozen things that were discussed. First, just a factual question, and the chairwoman's question about another, I think, Southern California facility. There may only been one. Was the answer there was only one rendering facility or one collection transport only facility? How would you answer that question?
It's the former, sir. There's only one public rendering facility in Southern California. That facility has, to my understanding, no poundage limits.
Okay, but stop. So, but what you're talking about doing collecting, transporting, not rendering. So you're not aware of any facility like that in Southern California?
I'm not sure that that's accurate, and I wouldn't want to represent that without consulting with my client.
Okay, but neither one, if there is, neither one of you know what their limits are, and it sounds like, correct? Okay.
I've been informed that there are no limits on either type of facility elsewhere, but I would want to confirm that.
All right, we don't have any facts here, okay. So let me ask Baker, so the way I read your proposed order, well, the trigger for you to start your collection operations is simply to submit the 3 permits with the provision you've also added, you'd agree to some training of personnel. Am I reading that right?
Yes, sir. And to be clear on training, absolutely all personnel will be trained before their operations begin. That's not a question.
Okay. Let's go over first the termination language that you raised that you disagreed with. And I'm trying to understand the concerns here and the differences, because I thought that the language, I guess it's depending on the numbering, like yours, it's 14. Theirs is 16, but basically yours said it terminates upon final compliance, which is completion operation of a new capital improvement described in section 7. And the way I read the district's language, it says the completion and operation of 3 new enclosures, ... which I read are the ones that are in section 7 and yours section 8 there. So I read there as just spelling out what section 7 or 8, depending on numbering, says. You have to complete those 3 elements. So help me better understand the fight there about the termination language.
I believe, sir, that the difference is that there are the 3 enclosures: the grease pit, the J&M skimmer, and the Centrisis trash bin.
Mm-hmm.
And then there is the PTE extension. There's the larger permanent total enclosure extension. What we had proposed is that once the 3 enclosures are completed and operational, that would terminate the OA. I believe what the district is suggesting is that the OA will remain in operation until they permit the extension of closure, which
okay, so it's the addition of and issuance of the permit to construct to expand the enclosure is the language that you object to.
I believe I'm characterizing the district's proposal correctly, and yes, that is the language we object to.
Do you agree, Ms. Sue, that's the difference between the language essentially?
Yes, that's the difference between the language.
And why do you want to add that language about and issuance of the permit?
Because if that language is not in there, theoretically, once the order for abatement ceases, there wouldn't be any conditions on their collections. And they also would need a permit to operate to be in compliance with district rules.
Well, if they're not in compliance, then you can shut them down.
Well, and there would be another order of abatement.
Yeah, there would be a gap between when they have a permit to construct and before the OA, or when the OA ends, where potentially there's no coverage from a violation of district rules. That's why we consider that an important fact for them to want in the order for abatement or into the conditions.
So,
well, it's implicit they have to comply with district rules. So, and we're not talking about 415 anymore. Hoping not you're trying to sneak that concept in here, right? Okay, so let me go back to the Baker. Then why do you have a problem with that additional language?
So if I'm understanding correctly, what the district is saying their concern is that when this board, if the board were to modify the OA, the terms of the modification, they're saying that, well, once the OA terminates, then Baker would sort of be in this lawless land where they don't have to comply with any rules. And that's not Baker's conception of this process.
Oh, just before you go on, you would have gotten permits for the grease pit, trash area, skimmer, and Centris trash bin renovations, correct?
Correct.
So you have to comply with those permits, so you're not lawless in that sense, but go ahead.
Right, right. And so I think what they're saying is, well, then you could just bring 1 million pounds of material into the PTE and have it sit there permanently. And that's certainly not the intention of or understanding of Baker of how this would operate. The provisions of or the limitations on the operations Baker would keep in place. I'm looking for that language, but this wouldn't be a situation where the Baker would be subject to no limitations at all once the OA is lifted. And if you look at Exhibit C, which is the transloading standard SOP, general conditions says Baker shall store a maximum of 175,000 pounds of hard material in its raw material enclosure prior to completion of the enclosure extension. So that rule, that SOP would remain in place, and that would be what Baker would do until the extension, the raw material extension is in place.
May I
So,
share?
hold on. So you're saying that in this interim, before the issuance of the permit to construct, and again, even the district's language doesn't say you have to construct it. You just have to have a permit issued. You're saying that anything in the SOP on the transloading, including whatever limit we agree on, would still apply.
Correct.
Did you have a comment to that, Ms. Sue, in reference to the explanation?
I'm glad Mr. Jiggins said that, but the point is, unless it's part of a abatement order, that is still effective. In effect, there's no enforceability mechanism. It's them promising they'll do it, but it's not part of an order that we're enforcing. So if they're agreeing to do that, I don't understand why then just have the order in place so that we can enforce whatever is in their procedures or whatever the conditions are in the abatement order.
Well, what I hear is the difference is instead of saying an issuance of the permit to construct, you'll say in the interim, blah, 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 still applies from the transloading SOPs. So if there's something trying to kind of reach some agreement here, if you can say, well, let's make sure that 175 where we agree and apply still, then maybe that's a substitute for your language and reach the same result, which you're protected from the lawless collection activity, so to speak.
But by those terms, by how Baker has written it, final compliance and determination of the abatement order happens once the completion of those 3 wastewater enclosures are done. So anything that's written there would be not in effect.
However, we can still keep jurisdiction over the facility.
That's true.
Oh, no, but it says, the language now says the order would terminate, so we wouldn't have any more jurisdiction. You see the problem we have here? I mean, I'm trying to work with you, but
Yes.
it doesn't work exactly. I think she makes a good point.
Yes, sir. And
I use it for the
Can I?
Malaysia.
Thank you. What if that, we don't terminate the order because you're coming back for a status hearing on August 7th. That determination
Yes.
can be made at that point, on that hearing date, and that it does not terminate. The board will still have jurisdiction when you come for a status hearing, and then at that time we will make the determination depending on what the situation is.
I think that is acceptable if that's what the board wishes to do. Another approach could to clarify what Member Pierman was pointing out. If you look at our orders and conditions, I think what this might be the issue. There's a sentence, 1, 2, 3. The 4th sentence starts upon termination of the 2nd modified order. That sentence could be, right now it says upon termination of the 2nd modified order, Baker may continue to conduct collection center operations in addition to use cooking oil and trap grease, etc., subject to the maintenance of the permanent capital and operational improvements as described in Baker's request to modify. That is what the language I'm pointing to, just to point out that these SOPs still apply. Those are operational improvements that are described. But if we want to make that more explicit, we could say in accordance with the standard operating procedures attached.
Because at this point, we don't know what will be in the permit to construct.
Right.
Certain conditions may be imposed, that might be an issue before the board. sort of be like, so if we don't let it, so if the board can still continue to have jurisdiction over it until later, after the status hearing.
Well, I see, I didn't see it that way. I thought we were gonna have jurisdiction for a long time, not just before the status hearing.
Yeah,
Right.
I mean,
It's gonna be a year. from
right,
now,
right,
so-
exactly. We can determine at that time how much further when the order will end, not when these actions take place, you know.
Well, you're kind of punting the issue, which may be okay. I mean, it makes a point. You're not gonna be ready to terminate the issue by August because you gotta do other construction anyway. So the question is whether we kind of punt that language about the termination to see if we can come up with some better understanding of this of the situation after construction, but before issuance of the permit, if indeed there is a gap. There may not be a gap, right? It depends on the processing, doesn't it, in terms of how long it takes? So it may be a moot point in practicality. Is that a possibility to kind of not put the termination language in there yet with this finality and revisit it later?
Yeah, I agree with you. It may be a moot point depending on how quickly construction and enclosures happens and when the permit to construct the extension occurs.
I think if I'm understanding correctly, then what we would do is not set a date certain for the status conference right now, but say that the status conference shall be scheduled in conjunction with the permitting of the extension, and then we would address those issues at that point.
Well, I thought, my thinking was, given the complexity, it's probably good to have a status conference somewhere midway anyway, to kind of help
Yes.
resolve any kind of problems that develop. And just see, you know, if you've been operating in the collection for 30 days and, you know, problems develop, maybe we can help address it collectively rather than having a big fight over it and things like that. So I would think we can have language that just says, you know, we'll determine the termination subsequently. But, you know, under no circumstance will terminate until at least these 3 steps are done. I mean, that's the minimum we can say.
And there's language on the status on August 7th.
Yeah, we're gonna change that.
Yeah, that's right. Yeah, so there's
we can, yeah, okay, all right. Well, we got a lot of stuff to do, so maybe you'll have to help us with the language. That might be one idea to handle that. Okay. Good, then let's look at this demonstration, 11A as proposed by the district. And I guess my first question is, I'll ask Baker, what do you see in their order, proposed order, as the consequences of that demonstration being, shall we say, unsuccessful?
Well, if the demonstration is unsuccessful, or if at any other time Baker determines that it can't operate the equipment in the enclosure as they're confident they can, then they would obviously have to modify the operations at a minimum. Baker is confident that this equipment will operate within the enclosure as expected. And so I think the concern about the demonstration was that, you know, without specific criteria, that it may be a situation where the district just says, no, we don't really like the look of it. And so while
and what would happen if they said that?
Well, I presume
the orders they proposed, I read it doesn't say they can do anything. They can't stop the collection process.
Okay.
The way I read it, but if I'm misreading it, let me know.
No, I don't think you're misreading it, sir. If the district is willing to clarify that that's their intent, that whatever the outcome of the demonstration, they're willing to allow operations to proceed, then yes, Baker will agree to do a demonstration.
Well, I wouldn't ask that. It just seems to me that, you know, you think you can do this, but you even haven't done it really in the context of just collecting and transporting. So it probably can't help you to have like a test run to prove your point. If it turns out, and we'll have them film it, it looks like a bunch of Keystone cops and things have fallen out of the trucks, things like that. You'd be stupid not to say, we're going to change our processes. If you refuse to do that and the video looks like Keystone cops, they can come here and seek to modify the order and show the video. So I don't see that's big a deal that they're going to stop you unless it's really a complete joke. And it's, if you're honest with us, you'd want to make sure that it's not a complete joke when you see the results of it. So it'll be a learning experience unless it's a disaster. You know, you can keep doing it, but hopefully if there's some problems, you kind of fix them. But as a district, what do you see as the consequences of the demonstration not being to your satisfaction directly under the order, first of all, if any?
We agree with your interpretation, Mr. Pearman, that it is meant to just have a demonstration. There's no mechanism here to stop the collections. And we just wanted them to do a dry run to make sure that they have worked everything out, that it will run smoothly, and we're able to see that.
That's certainly acceptable.
Okay, okay. Great. All right, next, this idea about the permit, I guess it's 8A as it just proposes about the permit extension. And if I read it correctly, and I think there was some confusion about issuance versus construction. The way I read it, we're talking about completing the construction of the 3 enclosures within 120 days of the issuance of the permits. And then you have 90 days to complete. I should say this way, you have 120 days to complete, but if you get to 90 days and you see, I guess, it's kind of confusing to me, and now I ask the district, because in one says they have 120 days to complete it, but then you say, once they get to 90 days, it has to be built, they have to stop collection operations. So I'm confused about the 2 different timeframes there. First, the district could explain that to me.
We were just trying to encourage them to complete it within 90 days, but still have the abatement order in effect. So it allowed them additional time to actually complete construction. And I believe this is a condition that Baker has already agreed to.
Yes, sir.
Okay, great. That was good. Okay, so now on the load issue, and we did talk about the long-term storage definition, which really wasn't a definition. Also in the transloading SOP, hard material pickup, item 2. And you used this term yourself about emergency situations. How would you give me some idea what you think would be an emergency situation that would cause you to increase the load?
Is that a question for me?
Mhm.
That would increase the holding time or the?
Well, it says on the hard material pickup, item 2, you anticipate receiving not more than 15 hard material truck load volumes per day, except in emergency situations. So if I'm a member of the public, I'd like to know what the emergency might be that would cause that.
It would be a situation in which either, for whatever reason, one truck can't contain the capacity that that's required from a particular customer, or where there would be material that would otherwise be sitting, rotting in some, at some customer's facility, rather than coming into the Baker facility to be pushed out. Or perhaps, a larger truck breaks down and 2 smaller trucks have to go pick up that load, turning it into, 16 loads instead of 15. Those types of situations.
Okay, well, so one way to read this, it doesn't say 15 trucks, it says 15 truckload volumes. So one can interpret that as a volume limit, not number of trucks, which would, if so, your argument about smaller trucks wouldn't really matter in a sense. So how did you interpret that, or how did the district interpret that use of the volumes as opposed to just trucks itself?
I had seen truckloads as meaning, and I had sort of anticipated that the district would interpret it as, a truck coming into the facility, but the board member makes a good point. And one other type of emergency situations could be large scale animal die-offs at some facilities, which has happened in other counties previously. So it's these sort of unanticipated things that can happen that require that we get that material out of into a rendering facility as soon as possible.
Okay, that sounds like emergency, but well, so what do you think about the idea that it's talking about 15 hard material truck load volumes, which at most are what, 15,000 a truck is the average, Mr. Venus, pounds?
The trucks have different sizes depending on the routes that they run, but my understanding is the largest truck has a maximum capacity of 50,000 pounds,
Mhm.
while many of the other trucks have smaller capacities, more in the range of the 15,000 that you had suggested.
Mr. Chairman, I believe Baker, Mr. Jiggins in his opening already said that they would agree to 20 truckloads maximum. So perhaps number 2 could just be struck in and write, Baker shall receive no more than 20 truck deliveries.
And did you want that emergency situation exemption though?
Well, I think if we're increasing it to 20, then in order to move this forward, we can agree to strike that emergency situation. If the county or the AQMD declares a state of emergency and wants the Baker or others to pick up more truckloads, I imagine there would be a mechanism for that to happen if something like that happened.
My concern is that you may run into it more than you think, and that other facilities are going to have an after hours beyond what the hours are stated here, and that you're going to have someone readily available and assigned to that after hours on a regular basis, like I had suggested before. Maybe once a month is enough. You'll know once you get started, whether you're going to run into that more or less. I would say a minimum maybe of once a quarter, a minimum. Because I see, because of the fact there are now only going to be 2 facilities in the South Coast AQMD region, logistically, some are going to want to go to one or the other. So I don't want a situation where it'll be a violation versus something that needs to be put in there just as a way of doing business.
We could, Madam Chair, we could leave it at 15 with the emergency provision and see how that works out. And then if there needs to be a change, or once we have a better read on how that will work, we could modify it as the board requires.
I think that would make a lot of sense.
But Ms. Sue, how would that comply with the prior statement that they take a 20 truck maximum? How would those work together, if at all, in the short term here?
The district would prefer 20 truck deliveries, period. And it seemed as though at the outset, Baker was okay with that, but it sounds like the chair would prefer a different language.
I would just want to add that there may be, in the case of an emergency, maybe you need to start the sentence, in the case of an emergency, there will be 1 day a quarter that will be allowed, because like I said, they're going to run into that. I don't see them not running into it.
We would be okay with that language. So 20 truck deliveries a day, 1 day a quarter, where for emergency purposes where they would be allowed to receive more. We would be okay with that language.
And extend those hours and have a qualified person there. And while you have me on that subject, I really want, I couldn't find it in here, and maybe I'm just missing it, but I really want to see that whomever is going to be the environmental specialist, that they are technically trained, whether that's from the local community college, which East Los Angeles College is right there. There's a facility called let's see, it's REBRAC. It's the Regional Environmental Business Resource Assistance Center. That's what it stands for. And it's strictly to approach and help companies of this nature to conduct business. And it trains them to understand what is hazmat, for instance, or what is, in this case, identifiable, whether it's per load or how that's going to work out, I don't know. But I would like to see much more technical training versus putting a hat on somebody and calling them an environmental specialist.
Now,
And I don't think it's in here.
Change it to 20 from 15.
Is it?
Oh,
I just see that it calls for an environmental specialist, but there's no requirements
Madam
there.
Chair, if I may add on that, I heard the name, Mr. Androli, in the testimony, a name from the past, who is the environmental specialist, Frank Tavrocoli, if I'm not mistaken. He used to work for the AQMD before he's an engineer, he
Yes,
used to work
I
here before.
remember that also,
You
but I
remember
think
that? Yeah.
I think we need to put it in here so that for
Well, they
going
may
forward.
replace him, somebody else, that's all, you know, so you need a qualified person,
Correct,
who knows? Yeah.
right.
Madam Chair, if I may, so yes, Frank Tavicoli is the existing environmental compliance specialist. Exhibit F is the job description that of what's required for that position. And obviously, in order to perform that job description, this person would need to be specifically trained at the high level that Mr. Tavicoli is. And so to the extent that the board wishes that to be clear, that anyone who's hired for this position has to be adequately trained for those specific requirements,
Yes.
I think that's fine.
Okay.
Baker, absolutely. I mean, Mr. Tavicoli is a perfect illustration of the caliber that we want to bring to this job.
Exactly. Thank you.
All right. So I guess where I left off is the 20 deliveries, and we had one at the qualification, except perhaps one per quarter for an emergency situation. So on this, the load limit, I want to be clear about our terms. Because I know the district mentioned no more than 60,000 pounds in the slab or on the slab. And I think maybe Baker used a term within the enclosure. So help me understand again, the 60,000 pound limit that the district wants is defined what? Anywhere on the premises within the, PTA, exactly what are you talking about there?
In the enclosure.
In the enclosure.
It's the floor of the enclosure, the slab.
Okay. So they could have other trucks somewhere else on the facility premises, if possible, at the same time, if they're covered?
Potentially, yes.
Okay. That your understanding of what they're proposing? I know you disagree with the number, but how we define it in the area?
Well, they had just today clarified that they're okay with TARP trucks being outside of the PTE in the facility. So now that is, yes, my understanding of their position as of today.
Does that change your position at all? I mean, you're still allowed, if I understand their change, you could theoretically have more than 60,000 in the facility, truck sitting there, but only 60,000 pounds worth in the enclosure. Does that satisfy your concerns about the limitations effect or restrictive effect?
No, it does not, for several reasons. One of them is operational. It's impossible to run the operation by incrementally bringing a truck in, dumping the load, pulling that truck out, pulling the, I guess, partially filled truck back in to fill it with the rest of it. But also, I don't think the district would or should. I mean, the district, I would assume, would prefer that the material be within a permanent and total enclosure, which is sort of the gold standard here, rather than waiting outside of that enclosure in a truck, just because the limit is 60,000 in the PTE.
But your language doesn't guarantee all of it would stay in the PTE either, though. You could still, under your language, you could have 40,000 in the enclosure and 100,000 sitting outside of it, right? Or am I misreading how you phrase yours? Please point that out to me.
Well, certainly that's not the intent of the language. I'll go to the specific language, but the way that this is to operate is that the truck enters the PTE as soon as possible and dumps its load, is fully rinsed, and leaves the facility.
Because I look in your 10B, you just say 175 in the raw material enclosure, which I guess still means on the slab is this terminology. And there's really no limitation on poundage elsewhere in the premises, unless I'm misreading it.
I think the premise for the 175 is the pit area being available, because that's where they would put a lot of the material. Also, having the pit available, that's where they're coming with the 175, so that you can store it inside versus outside.
So, I mean, I'm thinking there could be a truck just sitting in the premises somewhere, and that seems to be not dealt with under your language at all, except for I don't understand how that might work, sir.
So under the transloading standard operating procedure, which is Exhibit C.
Mhm.
If you look at page 2, hard material pickup, item 5 says, the transport vehicles carrying hard material shall be taken directly from the scale to the raw material enclosure or parking lot for staging before entering the raw material enclosure for offloading into the hard material pit. And so that is also within the raw material enclosure. So the point of that was to suggest that that truck will enter the PTE at the earliest possible opportunity, but provided that there may be a truck offloading within the PTE right then, and it would have to wait until it could come in. If we wish to clarify, use that language at the earliest possible opportunity to make that clarification in number 5, we certainly can do that. We can replace directly and add, and at the earliest possible opportunity, or some similar language if that is to the board's liking.
Okay, well, we'll see. I guess my point would just be whatever number we might settle on. This may not be your intent, but the way it's worded now, you could have items in the parking lot for staging, not in the PTE, be more than 175,000 pounds total there at any one time, which I'm not sure is what the district had in mind, and I'm not sure that we want that possibility, even though it's remote. So I'm thinking there'd be an overall cap that would include material sitting in the parking lot for staging, just to manage the amount that you bring at any one time. Anyway, that's one thought I have on that as we get to it. Okay, then let's look at the odor protection, odor response plan, etc. And I had a couple of questions that it ties to the district's condition, sir. And basically, I'm looking beginning at the 3rd page, 4th page 2, understanding some of the language about odors and things like that. And say on 3.0, page 3 of the odor response plan, table 1. I'm trying to understand the sequence and the timing of this. So under raw rendering material, there's potential odors. There's an incident. Someone says they smell something. So you'll conduct a complete walkthrough. And then I guess the second bullet point is you identify after the walkthrough. Should I imply that means after the walkthrough, you identify any spills and clean or direct them to be cleaned immediately? Or is that a separate step?
So this, you're looking at the second bullet point in odor control practices?
Yeah, where it says shall identify any spills, is that after the walkthrough, or is this a separate bullet point that's unrelated to the first one about a walkthrough?
Oh, I think it is related. Obviously, there, to the extent there was a spill outside of the raw material handling facility, that would be addressed as well. But yes, I think the part of there's a potential odor. So the first thing you do is thoroughly inspect the operation to see if you can identify an odor source or whether there is some problem with how things are operating.
All right, and then the last bullet point says this walkthrough shall occur on the business day of the odor complaint or the first business day thereafter. So first, your intent to collect is only 5 days a week, 6 days a week, 7 days a week?
Yeah, I believe it's 6 days a week and closed on Sundays.
Okay, 6 days, not Sunday. So by business day, normally that means Monday through Friday, excluding holidays. In this context, is that what you meant?
I think the idea is that if the facility is closed, or if the complaint comes, at night or on a Sunday evening or something like that, that it would be difficult to go in and inspect the facility without, first of all, there'd be no operation, but it'd be difficult to inspect the facility at that period in time.
Okay. But if I'm living in the area and there's an odor on Saturday under this, the first business day would be Monday, so they might have to suffer 2 days without the odor being treated, the way I read this as a possibility.
So if it were Saturday night after operations closed on Saturday, because there would be operation on Saturday, I take the board member's point, and if there's that's certainly not the intent to allow things to sit, but if there's some codicil that the board wishes to add there to clarify that if something comes in that needs to be inspected on Sunday, I'm sure that Baker would inspect on Sunday.
Maybe following on the chairwoman's comments, would you always have someone with some authority and understanding of odors and environmental issues at the plant, the facility, every time there's any movement of collection material, so that there's a person who has the authority and knows something about how to clean it up, rather than having to call somebody to come in from home, we got a problem? How do you see that working practically?
Yes, absolutely. So that there was a point made earlier that the ECS couldn't, he's not a robot. He has to sleep and he has to attend to his family and other business, but there will be someone at the facility with the training to deal with issues, the ability to call either the ECS or the plant manager, or otherwise have the authority to deal with any issue that arises during operations. I think that's standard practice for any industrial operation.
Okay, good. So I probably have to take a lunch break soon. I still have more questions, but I asked these questions because the district had a proposal that touched on one idea that I had, and this dealt with the odor detection. And what they basically said is, if an odor is detected, you have to remediate. And then again, we went to the discussion that ultimately, if you can't fix it or whatever, you could have to stop collecting material at the facility. And so, again, if I'm someone living in the area who suffered through prior odor issues with Baker's presence, that's kind of an important concept. And you're saying Baker wants to be a good citizen, and the whole point is to not have odors. I think the whole point of the district limitation was their witness testified that he did not think you could control the odors by the mechanism you employed if you go over 65,000 pounds. So, we've done this in other cases, and whether you thought about something that uses the odor as the litmus test. If there are odors, then you slow your roll. You don't bring as much material in. If you are a good citizen and this works and there are very few complaints, whatever is a reasonable number, there's only 2 a month, then you can load more the next month. We did that with, I think, one of the landfills where, if there were complaints, they had to kind of lessen the face they use or take in less. But if they were good citizens, the next month they could use more, and we expand the capacity. So the key here is the odors. We just can't have odors generated from this process. We hope it works, but we have to make sure if it doesn't work, you can't just keep and subject the people in the vicinity to odors. So just think about whether there's a concept of odor problems that can't be alleviated, that therefore it means then you must slow your roll, maybe call for fewer trucks, or it can be a carrot that if you're a good citizen and we only get 2 complaints, they might want you to start at 135, but if you did good the first 25 of the day of the month, only 2 complaints, you get 175 the next month. I mean, think about that as some sort of mechanism, because we just don't know. You don't know for sure. We can't leave the community subject to hoping it works and some long administrative process to fix the problem. So anyway, that's just a thought I wanted to at least bring to your attention before you go to lunch and see if something makes sense.
If I may add, if you can narrow it down, because I think the point I brought earlier is it could be your wastewater treatment, which is not related to transloading, because this is shut down the transloading operation. So if the source is identified as from the transloading operation, either the truck or material seeping out, then this will kick in, but not, unfortunately, if you have another problem somewhere due to a breakdown or something.
Understood. I mean, one thing I just want to make sure that the point is made. The point is minimizing odors. Odors cannot be eliminated in this area. That's not because of Baker. It's because of the long history in this area and the existing industrial operations in the area. So minimization of odors is the key. We do believe that we have very strong SOPs and operational controls and structural controls and improvements in place to do that minimization. There is the nuisance law that remains in place and available to the district if there were some dispute that rose to the issue to that level. I certainly hope there would not be. And I think if there were odors that are identified as not minimized and are related to Baker's operations, then Baker will have to make those considerations and adaptations in order to minimize those odors, and is committed to doing that. The concern is just that, to the points that were made earlier today, detecting an odor at the property line is not and has never been a standard that is imposed on the industrial operations anywhere else in this community. And so we're trying to find that way to be able to keep a viable and important operation, to restart it for the community, but also to be respectful and attentive to those concerns about odor that rise to a level that require remediation.
So I would just take a break and like.
Yeah. Okay, 45 minutes? Okay,
Yeah, 1 o'clock.
let's take 45 minutes. We're off the clock.
Recording stopped.
Okay, we can start the recording again, and we left off with Mr. Pearman.
Recording in progress.
No further questions at this time.
Mr. Belkapua.
You want to ask them if they have any questions first?
Okay, but I want to go to my board, finish with the board members.
Oh, first, okay.
Dr. Abraham or Mr. Ali?
I'm here, but no comments.
Any questions, Dr. Abraham? Okay. Okay. All right, Mr. Gigenis, did you have any other questions that you wanted? You want to ask him questions? Okay.
On your. Oh, I'm sorry. Mr. Gigenis, on your SOP, the transloading SOP, hard material loading, it's on page 3 and 1, item 1. It says that based on receiving 1 to 15 truck load volumes, of hard material per day facilities, anticipate loading 0 to 10. What 0 to 10? When we say 0, that means no loading, offloading at all. Is that the case, or
Mr. Belkapua?
what situation that would be?
I'm sorry, excuse me. Can you just refer to which exhibit you're speaking?
This is the transloading standard operating procedure. I think it's Baker's Exhibit C.
Okay, thank
And
you.
it's on page 3, page 3, item 1 on the hard material loading.
Thank you.
And it says, anticipates loading 0 to 10 trailers per day.
Yes, sir. And I think leaving 0 trailers leaving the facility would be an anomalous situation. It would not be normal, but I presume it would be if only a minimal amount of material came in that day that couldn't be loaded onto a truck to leave for a rendering facility, then that material would leave on the next full load.
Okay. So, okay, based on 1 to 15. So let's say if you got 1 that day or 2 and it's not enough, you're saying then none will leave that day and they'll stay more than 24 hours.
That's correct. So for instance, it wouldn't be in anyone's interest for 5,000 pounds of material to get into a 50,000 pound truck and leave, or a 50,000 pound payload truck and drive to Arizona to be rendered, or drive to somewhere else and out of the county to be rendered. It would be a waste of gasoline, a waste, it'd put another truck on the road. It wouldn't be an efficient process. So for many reasons, you would wait for a full truckload, which shouldn't, again, in a normal situation, there would not be less than a full truckload coming in on a day.
Okay. And I've seen elsewhere, maybe in the staff report, about disinfecting the truck or as needed. I know I just see clean, shell rinse. Does that include disinfecting as needed? If it's that case?
I believe that the cleaning procedure involves washing the truck out of material, washing the truck tires and so forth. But I would have to ask my client to know whether there's a disinfecting process.
And if I were to suggest adding a language as needed, would that be something that, if that's part of the SOP?
I think if you give us a few minutes to confer on that.
Yeah, and I recently had to load a dead possum in the front yard. It was outside maybe a day or two to put in the trash can, and the smell was, even with the closed lid and the air moving, because there's leaks or whatever, I had to move it out to the front yard. When the trash collected 2 days later, maggots were in the tank. I had to disinfect it with bleach, and that's where my thing is coming, because you collect dead carcasses and so forth, animal carcasses and different stages of decay. So I just, because if your truck is going out, I'm just,
I think first of all, the hard material that Baker would be collecting generally is refrigerated butcher remains that are coming from food service facilities like a butcher or a grocery store or a food processing facility. Not there are facilities that process roadkill, and those are a much different scenario that have a lot of those types of situations that you're describing. So I think there's less of that acute issue here, but I will certainly confer and come back.
And the last thing, spills would include not just material, but it could be liquid spills too.
If you mean in terms of identifying and cleaning up spills,
Yes,
absolutely, yes, yeah. The spills would be whatever material is spilled. That the idea is to clean that up.
Okay. All right. I have no further questions. Thank you.
Mr. Pearman, do you have any other questions?
No.
Okay, Ms. Sue, do you have any other concerns that you wanted to air and get to Baker as well as the board?
Just wanted to say that a revised abatement order is actually allowing them to start operations when they normally wouldn't. So please keep that in mind when drafting conditions. Why we want to be so strict is we're actually allowing them to do something they wouldn't normally be able to do at this point. And, you know, both parties are in agreement that we want them to start collections, but we want conditions to protect the public from potential odors.
Thank you. Okay, and other than what was discussed already, are there any issues that you feel have not been agreed upon and that are still outstanding?
I believe the hearing board has asked questions. I cover any points of disagreement.
Okay, thank you. Mr. Giginis?
We agree that the hearing board has addressed all the existing points of contention. We appreciate the hearing board's time. And I would just remark that actually this is a collection or transloading operation that we're talking about, not a rendering operation, which is what the subject of the OA is. While it does prohibit raw material from coming onto the facility, we're not talking about restarting the operation that was prohibited.
Understood. Okay. All right, board members. This to me is a huge undertaking because of two reasons. Obviously, we want to protect the public, and obviously we want a business to be able to operate, but operate within the parameters of what the district feels would be fair to the public as well as being fair to the business. And that's where we, as board members, have the duty to find that balance. And I don't know that we're there yet. Mr. Pearman has been very good about providing some language as well as Mr. Balagopalan. And I think you've heard my concerns as well. So I think we're at the point that we can possibly, what do you think, Mr. Pearman, offer something that we can live with, if you will. Yet, as I mentioned before, I don't want to lose jurisdiction. I want it, it's almost like a living document. It's almost like the fact that, okay, we're at this point, and as was mentioned earlier, maybe we're a little too soon on some things. However, I think that the concerns of the district are real, and that we can, I think we can make them work if there's compromise between both sides. I hear it from both sides. That's what we want, obviously. Of course, we want your workers to come back to work and earn a living, but we want it to do not only for their safety, but the communities as well. So
I can, yeah.
who wants to begin?
Yeah, no, I was going to say, I drawn 3 boxes here in my note. Rendering, Rule 415, I crossed it out because they're not rendering, the definition of rendering. The trap grease is a separate and distinct operation, separate from the collection and the transloading. I think in some, there's a mix up in some other condition where conflated between the two, between the transloading and the, somehow it's tied in that the PTE that is talked about is for the wastewater treatment and so forth. That's really related more to the the oil, the cooking oil operation and controlling, which is very good, having put control on that, or PTE. And the reason I think two of them have, if I'm not mistaken, are going to a scrubber or an afterburner, because when you put a PTE, you're containing the air inside the enclosure. It has to go somewhere, and as it accumulates, it becomes foul. So getting it to an afterburner or a scrubber scrubs it, gets it. You know, you got the exchange. I'm kind of disappointed. I didn't see that requirement in the order for the main enclosure, which is really what you're the transloading operation for the, you know, and I don't know if the engineer, when he issues the PC, will may have a condition and thing, but I don't know. If I had the ability, I would say don't grant it until there is a negative air enclosure and venting to a scrubber or a biofilter or some other type of control, because you do have a good, I think, curtain, air curtain, but that's again due to 415. But what it does, and it contains the foul air within the PT. So when you open the door, the air doesn't go out. So it's a containment, not really necessary control, because it doesn't reduce or anything. So where's the air going? It's going to escape to the vents, to the openings, and so forth. And so you will have this release over time into the air outside, beyond your fence line. And you're going to have the same issues maybe as you had before, where the public are going to be sick. So I think it will be more for Baker to rethink, you know, do the investment up front. You were paying $400,000 for notice of violation. That money could have been spent for, I mean, a containment system, basically, and that will reduce substantially the periodic release. You will still have release when a scrubber fails or something happens, but at least it's episodic and not, you know, a constant release of foul air, because the foul air in the PT, in my opinion, is going to be released. It's going to go out, maybe gradually, but it's going to go, and it's going to start creating more issues further down the road, you know. So I strongly, Mr. Androli, take it to management, rethink, you know, just like I think it was pointed out in the staff report and in the Darling's operation, they have a PTE, they have a control, you know. It's a humongous undertaking, capital cost, but having said all that, I do think it is appropriate to allow, I think the district wants to see the demonstration. It looks like there's no objection, as long as all they want to do is see it and not say you cannot do this or cannot do that. They just want to observe it and get an idea what has been done, how you maneuver, do the operation. But I do believe 60,000 will not be adequate, as you was pointed out, to sustain a business. And you need more, and you need to use a pit. And the pit, you need to then, as you indicated, put the plates on it, then submit, put some language, submit within 5 days, all that information that the engineer needs to know the modification you're going to make. In the interim, that's an interim measure that you're doing until the permit to construct is issued, because then you will remove that, my understanding is, and put the screws back and use the other overhead screw conveyor and so forth to do that. So you can still submit the information. So he has updated and put it this as an interim measure, but submit the information, because he was caught completely unaware, and that was not the way you want to do it. And I think I would propose language like in 210, Rule 210, that says, and I'll read that language. So the burden is also on both sides, that if you don't provide the information that the engineer is asking within 120 days, the engineer can deny it. You know, so I think that's sort of fair. So saying, if we don't issue it in 120 days, you got to resubmit. So I think, so I would propose a language in Rule 210C that says an application for a permit to construct shall be denied 120 days after their filing if the applicant has not submitted sufficient information to enable the executive officer to deem it complete, unless the executive officer has in writing extended the time. So I would propose that instead of saying, saying if you don't do it if the permit is not issued within 120 days. So that's another change I was going to propose. I would propose that we do allow the 175,000 pounds, do allow the flexibility in the hours as you indicated. I think your language on once a quarter, for emergency use. 20 loads is what was proposed.
But are you also suggesting that they purchase a scrubber?
No, I'm not suggesting that. I think I'm suggesting actually they look seriously into it, but that's up to the engineer who's processing the permit, however he's going to, what he determines as how it does the evaluation, whether it's backed or whatever. That's I don't want to overstep, or I cannot overstep the authority of the district permit engineer. But I was kind of disappointed I didn't see any language regarding that, or to look at the control or looking at negative air on that enclosure, because like I said, the foul air has to go somewhere. It's going to go out. It's just one, like I said, that example I gave in just the one possum, it was so bad I had to move the trash can from the side of the house to the front. My wife was complaining it was terrible, So we saw the Ms. Sue showed us the exhibit 17, and that was just a portion of the material in there. I think that there's another further down in that exhibit 20, or the humongous amount of material in there. And granted, Baker's doing a service to the community, and I think the community, in one sense, glad, because if they didn't do it, where the material is going to go. So having them doing the recycling, but at the same time, things will happen. Things will break down. That's what happened, I think, in the last hearing in 2022. There was so much material in there because I think the screw broke down and the material was leaking out and so forth. And that can happen. That's part of the operation of a facility. But if you have controls on air and movement and so forth, then at least it's minimized or reduced. It's not an odor-free operation in any means. The trucks with tarps, there's air will leak out. There's movement of air. You will still get the smell. And I think that's a good idea not to have them sit out for a long time. As soon as you can move it into the PT, that's the best solution. Otherwise, it's going to create more issues in the neighborhood.
Did you want to offer some language?
Yeah, I will offer. I just want to, and wait for that. And that, and I see, I think the odor detection, I think, I was going to say, if the inspector or Baker find that the odor is related to the transloading operation, then they should take the measures to control it. But if it's, and I think the way the condition read, then just stop, if they cannot mitigate or minimize it, then stop receiving material until they can. But I just wanted to tie it into the transloading operation, not to the other operation of the facility, which is distinct. By the way, I think there may be about, when I think at this first amendment, we got in the table of a list of facilities, maybe about 20 odd facilities in the basin that handles waste. Crab grease, none of them is subject to 415. It's a distinct operation. The district was, in the staff report I looked, proposing a separate rule for crab grease operation, but that has not, happened yet. But I think Baker's ahead of the game in that sense. Maybe they may be used as the model if the district chooses to develop the rule, because they're enclosing those areas and venting it to a control system. Mm-hmm. But where they're behind not, and is the negative air on the receiving area. So I think those were so what I'm saying is, I think willing to grant what Baker's requesting, the higher throughput, the flexibility in the operation, what the district wants as far as a demonstration, and then keeping the response to complaints, and let me see. I'll go. That's the big picture, and I'll go down to the detail afterwards.
I am still concerned about competitiveness. And if the other facility that is doing the same type of work is being allowed to go beyond the 60 pounds and Baker is not, I don't think that that's fair to them and or the community that they serve. So I'm in agreement with you in regards to the 175. That being said, I absolutely want to make sure that, as we discussed already, that the environmental specialist, and I think you're going to have two. I don't see how you can't, because that one person cannot be expected, as was mentioned earlier, to provide all of those hours of coverage that you need to have. And if there's an emergency situation, as we've discussed also before, that would also allow for that, and that the technical training is provided to that person as well. Those are my major concerns, to be able to have Baker still operate, still be competitive, and still operate within the guidelines of, not even the guidelines, the rules and regs of the AQMD. With what we're discussing today, I think if we tweak them somewhat, as we're doing, I think it's doable.
And I was going to add, Madam Chair, also, I think terminating the order upon installing those control, I think we need to, as Mr. Payman said, punt it down the road, and keep us that order still under our jurisdiction, and not, say, oh, once you've constructed those enclosures, then the order terminates. I think when they come back for a status hearing, right now it's scheduled for August 7th, but if it's later, then we can make the determination there. There's one thing I forgot, and if you look at in 13, that's on the district's proposal, and I meant to ask that, and I didn't. I know we're close. It says that if the hearing board decides to incorporate Baker standard operating procedures, the following provisions is suggested. If there's a conflict between the standard operating procedure and the condition attachment A, the condition attachment A prevail and must be followed. That is kind of loaded, because then some of the things that we said to change now suddenly gets overridden. I'm not sure exactly what conflicts between the SOP is it, it's not very clear, and I should have asked for that, So I don't know if board members have any suggestion on that.
Well,
Mr.
I
Pearman?
think generally it says our order will trump the SOP. So you're right. I think that we'll have to read our SOP carefully, as should the parties, but for now, our order takes precedent over the SOP that might conflict. And one suggestion I have is, if we come back for an next status conference, parties can look at that and see if they want some things that need modified in our order.
Yeah, that's okay.
So my thoughts on the order, I don't know if we can get all the language down now, but looking at the districts as the template, I'm suggesting that in the conclusions at paragraph 3, we simply say the second modified order's termination conditions shall be established in a subsequent status hearing. Okay, the second modified order's termination conditions shall be established in a subsequent status hearing. That's changing the conclusion, paragraph 3. And then looking at attachment A, so in paragraph 4, it seems to me that there's a duplication issue of the first sentence of 4 with 11A. Do you see that as well? It's duplicated there? Or
And 11A.
4, I think 4 is a new one, right? That was installed.
Attachment A. Your second month. Paragraph 4, the first sentence. Is it the same as 11A?
That's not what I see on my document. 11A is Baker shall not use the facility as a collection center until it's conducted a demonstration.
Right.
4, I
And
see.
then look at 11A.
I think you're right.
Oh,
Thank you. So
Yeah,
we're gonna
4,
strike it
the
in
first
4.
sentence of
Yeah,
4.
it makes it's duplicative. Okay, we'll
It's
strike 4, this first sentence of 4. But I think that the language remaining will go back to Mr. Balakapan in terms of whether he wants any special language here about the permit timing. I defer to him if there's any changes
I can propose
there.
that, yeah.
You can propose that later.
Yes.
And then under 8A, again, looking at the district version, I propose to change it near the end where we had the issue about if the enclosure not completed and petitioning the hearing board. I'd like it to read, if the enclosures cannot be completed within 120 days, and if Baker and the district are unable to reach agreement regarding an extension to Baker's time to complete the enclosures, either party may submit to the hearing board a request for extension to complete the enclosures or for suspension of collection operations until such enclosures are complete. So there's no automatic cessation, but if you can't reach agreement, then you can come to us and either get more time or we'll side with the district and you'll have to suspend collection operations.
Does that sound fair
And
to both
then,
parties?
that would be the end of that sentence, until such enclosures are complete, and the last clause, or until the hearing board length, et cetera, is stricken into my language here. Then under B, again, I'll defer to Mr. Balakopan if there's any change to that section about the permit, et cetera. And then my next comment will be on 11A, which will be a combination here. We'll retain the demonstration, but also add, as Baker had said, and until all applications for the permit to construct the 3 enclosures have been submitted, and that all cognizant personnel at the Baker facility have been trained in the requirements of this order and the relevant SOPs. So there'll be 3 triggers to actually start as a collection facility. The demonstration remains, understanding it's not a sanction by its terms, and that you have submitted the application to construct as Baker's proposed in their draft, and as the chairwoman suggested, that there's training done for the cognizant personnel of the requirements of this order and the relevant SOPs. So that'll be in 11A. And then under 11C, as proposed by the district, I would strike that about the pit. And again, my theory is that the whole point here is odor control. Apparently the district felt that it'd be hard to control materials there. Again, my view is the proof is in the pudding. If there are not any odors, then they can do it. If the odors develop, they can't. Item 11D, I would change that to 9 p.m. except for an emergency. Only received from 6 a.m. to 9 p.m. except for an emergency. And then item E would add the language we discussed in terms of the 20 deliveries, except for one time every 90 days emergency situation that causes them to exceed that number. Except for one time per 90 days, excuse me, emergency situation that causes them to exceed that number of the 20 deliveries per day. And then on the item F, I would change it to 10 p.m. The removal.
Just a quick on B, 11B, changing 62.
Oh yeah, I'm sorry. I'll get to that in a second. Okay. Yeah. All right. Now, going back to the poundage as was suggested, I'm going to suggest that we go with the 175,000 language as well. So I agree with my fellow board members on that. They'll have a change to the odor control that might be relevant to that. Going to item 12, odor best management practices, item small I. I think Baker was right that the rule that was based upon from 415E does talk about in the enclosure or covered containers. So I think the word or covered containers should be added after receiving area enclosure or covered in containers, which I think is what Baker had pointed out. And then under Roman numeral 7, the odor detection. I have a few thoughts here. I think that initially in the sentence, if odors are still detected, Baker shall take additional remedial measures as requested by the South Coast AQMD personnel, excluding immediately foregoing receipt of additional materials, et cetera, et cetera. However, if in any month there is a NOV based upon odor complaints, then the following month, the remedial measures may include immediately foregoing receipt of additional materials for collection or removal of existing materials within 3 hours. So again, if everything's going fine, then we're agreeing that perhaps the district's statement it could stop the operations is overborne. But if we get an NOV for odor, which again is not just one complaint, but a number of verified complaints in a certain period of time for odor, then they can, among other things, put back this potential restriction of stopping the removal. And I would add the word reasonably requested in the 1, 2, 3, 6 line where it says shall take additional remedial measures as requested. I'll put the word reasonably there in all cases to sort of give Baker a little bit more comfort in that regard. And then I would agree with the addition that the AQMD suggested, as Mr. Velkapan suggested, that will include the language that this attachment A trumps the SOPs. The hearing date, I won't be here on the 7th. I might be able to do it remote, but perhaps we could pick a different date for that next status conference. And then 16 would be modified to state, as I did before, the second modified orders termination condition shall be set at a subsequent status conference. And then the only thing I would add would be just to have language that Mr. Velkapan suggests clearly on his issues, and whether Madam Chair had some specific language she wanted about the training, if you would, of the ECS personnel. In fact, I would add in the order control that an ECS or his or her designee shall be on call at the facility at all operating hours. So that would be a new 8, I guess, Roman 9, subpart 9.
With technical training and or certification.
Well, you say what you want exactly, then we put that in here, yeah.
We're adding a whole new, okay, I would say that the ECS position is to be filled by a person who has had technical training or experience in this field. How's that? That's short and sweet.
Go ahead and read it aloud. Just
Okay,
wait a second.
that
Hold on. He's still talking.
that the ECS position is to be filled by a person who has had technical training and or possesses this training. Wait a minute, I just read this wrong. That position is to be filled by a person who had technical training or training in this field, or possesses training in this field.
So maybe before we go to Mohan's specific language too, do you want to see their reaction to those potential comments that I made? Anything that's a deal breaker from your standpoint?
Thank you very much. I think for almost all of this are things that can be lived with, but there is one deal breaker, and I have to be clear about it, and I feel that we've been clear about it since the beginning, that the operation will fail if all material must be removed from the facility by 10 p.m. every day. That's something that we cannot do. And if it is a requirement, I think I've just conferred with my client. I think that they won't be able to do the operation.
Have they ever tried?
I'm sorry.
I'm sorry.
Well, they haven't had a collection facility, and they've been shut down for nearly 2 years. But they do understand the logistics of the operation, and we discussed my comments just now, and I am told that is the case, which has been our consistent position.
Was there surely some of it can be cleared. I mean, is there some like minimum number that you feel you have to leave there or can't adequately dispose of, a reasonable threshold? I mean, the notion you have to have 175 there overnight is going to be disconcerting to the neighbors, I'm sure.
And that's why we're here. That's what started this whole thing, was the fact that material that was left there that wasn't washed down accumulated and became a problem for all of the surrounding area, as well as, their own employees, which they can't deny. And we've
Right.
seen pictures of that material, and that has not, I can never forget that.
Absolutely, Madam Chair.
Excuse me, just have a question.
Oh,
Madam
Mr.
Chair.
Rowley, I'm sorry, go ahead.
So to the respondent, if in fact you were to leave the items overnight, as it were, how do you propose to mitigate any odors?
All of the material will remain in the PTE. There will be no raw material outside the PTE overnight. There will be no spills or exposed areas outside of the PTE. The situation that Madam Chair had described included material that was offloaded outside of the PTE on the star dock. It included the rendering, all of the rendering equipment, which is not within a PTE. All of that is shut down and not used and not usable. It included, sorry.
So as I asked during the last session, this is a novel facility, right?
At Baker, absolutely. I'm not aware whether there's, yes.
So to my board colleagues, let's see where it goes. We maintain jurisdiction. And if there's an issue, then we deal with it accordingly. But to spend another hour or so trying to arbitrate something that none of us have any context, they don't even have context. But if the items are stored within the protective environment, then let's see where it goes. Because we'll be here another hour or two, or continuing this to another day, trying to arbitrate something in a future state.
No, he's talking about today's hearing. But can I just ask a question? The language, at least in the order of the, okay, so yeah, the term is facility. And facility is actually the entire Bandini address by definition. So at a minimum, can it be that it might be overnight in the PTE, but nothing outside the overnight? At least as one clarification.
Yes, sir.
Okay. All right. Just to understand that.
Ms. Sue, how do you feel about that?
We believe it's important for material to be moved out of the enclosure entirely so washdown can be conducted and turnover of material is guaranteed. And in addition, with Mr. Pearman's addition regarding the emergency provisions, if an inclusion can also be had for notice to the district when there is an emergency.
Okay, but Mr. I'm sorry.
For the PTE, the concern too is that, sorry, the concern about this particular PTE is that it is not vented to a control system. There is no scrubber here. There is no afterburner. There's a facility that just has air curtains and it's not under negative pressure. So odors that are in there are going to be escaping. So you do want to consider how long are we going to have a lot of material in here? If it's 12 additional hours over the night, and then when is this exactly going to be picked up and moved? We haven't really gotten a definitive answer on that either. What is the time period for, what's the limit on how much that material can stay there in the enclosure?
So
I don't agree with 24 hours. I absolutely don't agree with that. I don't think that's fair to the surrounding area, the residents that are there as well. That's not going to just stay there. It'll be picked up and the odors will go to the surrounding community. So,
Madam Chair, can I ask a question? Can I ask a question?
Mr. Rowley.
How do we know? How do we know what's going to transpire? And if in fact it does occur, then we can deal with them accordingly at that moment in time. We're continuing under the supposition or belief that they're conducting a rendering process. And the
No.
objective here is to try to move us along. But the reality is that either side is going to have to give on this. And I believe that they ought to have an opportunity to at least see if they can contain, mitigate, and manage. If not, then we'll deal with them accordingly. We're going to maintain jurisdiction of the facility for the succeeding months.
Yes, but between now and then, theoretically, I'm not looking at this as a rendering. I'm looking at this as straight out material that's going to be there, that's going to be obviously getting more or odorous as time goes on, hour by hour. And what we're trying to figure out here, what's the breaking point here? What's the breaking point that is feasible, if at all, and what is that time frame?
If I may, Madam Chair. So the first day we were here, we spoke about the washdown procedure, and it seemed that everybody had agreed that a weekly washdown of the pit was appropriate. Baker made that concession and is committed to doing a weekly washdown of the pit. I'd understood that process or that concession and that discussion was around the idea that there is going to be material moving through here on a regular basis that would then be cleared by Sunday each week. The normal time for material to stay in this facility would be 24 hours or less. The normal turnover, sort of maximum turnover time that's anticipated would be 3 days or less. As was testified to, that's the only evidence we have on these issues. The flexibility, again, is simply required because this is a procedure, this is a process where material comes in and goes out on a regular basis and has a lot of moving parts. The last thing I would say is the reason this issue is before this hearing board is because there's an order of abatement that had to do with the rendering process. If this were a new facility, if this were something that was happening that wasn't, didn't have the history here, this would not be an issue. There is no rule restricting the amount of material or time that material can stay at a collection facility that's outside of the normal, typical nuisance odor provisions that are within the district's ability to enforce, including here. So I do think that we have safeguards here that will prevent the type of situation that Madam Chair has expressed.
To be honest with you, the more I heard, the more I got concerned in regards to the pit. And how are you going to wash it down? Where's that water going to go? Is there any drainage? Are there any power washers? We discussed all of that after the testimony came in that there was going to be a weekly wash down. And that's when I started to get more concerned about, okay, even if you have it on a weekly basis, where's that material going and where's that liquid going? And in my, just thinking about inspecting different facilities, how can you not have some type of drainage?
Madam Chair, there will be drainage, this is a discussion that happened at our last meeting. So that drainage, the engineering of that drainage has been figured out.
Okay, do you have a new rendering?
We don't have any rendering at this facility.
Okay, that's the wrong word. Do you have a schematic?
Render.
Sorry.
Because that would be helpful for us to understand and look at what exactly is the process. How is that all going to flow? I don't know how my fellow board members feel other than one. Of course, we want to get that material out of there so that there's not an issue of an odor nuisance issue that we're going to get calls on, and that our inspector is going to go out there and there's going to be a notice of violation. We all want to avoid that, right? So how do we get to that point? What's the amount of time that can possibly be realistic in reference to avoiding all of that? Any comments on that, board members?
No, we've had a lot of options. One question is maybe if I just defer it briefly so we know what's left here. Did the district have any heartburn or deal breakers from the way I recited the proposed changes I would make and that Mr. Volkapon would make?
We'll defer to the hearing board. We have limited authority on some of these conditions to move. So I'll leave it at that.
That doesn't help us.
Well, my only suggestion is, we could quickly come back with a status conference we could keep, it doesn't matter the language here because they're not going to start using the PTE for collections in a week or so. So we could leave the district's language, it doesn't matter, but ask them to come back in a couple of weeks with any alternate language or maybe some more evidence that would make you feel comfortable that the overnight storage is acceptable. Or they could say, we don't need to have 175,000 pounds there, but we need 40 or 60 or something like that. Then they have no facts to give us in that statement. That might be a more reasonable way to do it, but still allow the process to go forward.
So if I understood Board Member Pearman correctly, then the board would draft the proposed or revise the proposed findings and conclusions in the manner that has generally been described here, leaving that one provision open, subject to further evidence, providing comfort regarding concerns one way or the other. Is that generally?
That could be the process if the parties agreed. If there was no order in place, you could still start your work to move it along, or we have to issue the order knowing that we'll come back and revisit 11F in a week or two.
And I'm looking at the calendar, the hearing board calendar. Is 2 weeks adequate?
If you give me 1 minute.
Does the district feel either process has any particular legal
Wednesday?
or non-legal validity?
Oh, I'm kind of
For
looking at the
example?
19th. Oh, okay. We got to that.
For example, this would not prevent them from getting, applying for permits, assuming this would ever pass and things of that nature, I suppose.
They can always apply for permits to construct, and they, as stated by Mr. Kandahari, they've already applied for certain permits to construct. We don't believe that they can start collections until there is a revised order for abatement. And in terms of our concerns, we are concerned with any materials remaining overnight.
Okay. In the interim, if you feel some of the other conditions I suggested, high authority creates a problem, you need to let us know by the next status conference.
So let me ask a question. What about if we come back on the 20, if we came back on the 26th, would that give everybody ample time?
Well, I'm just looking at the book right now, and on the 26th, we have the city of Fontana, and
Right,
we
but that
have
shouldn't-
LA.
Oh, we have 2 on the 26th?
Yes, we have 2 on the 26th and possibly 3 because Amoresco is on
Yeah,
both
Amoresco.
the 25th and the 26th. Yeah, it's penciled in on both.
Okay, so then can we look at the 28th?
That's a Friday.
That's a Friday, yeah.
No, I'm
Or,
sorry, 27th. I'm sorry, the 27th.
What is a Nesco? Which one? Is that a regular bear?
Chiquita Canyon at Johnson.
Okay, forget the 25th. Then that would be, we would be here 3 days that week, so that would be Thursday, the 27th. Unless
So well, then let me ask you this. How about if we look at July 2nd? And the reason why I'm saying they need ample time, I was a little taken
Yeah, I
aback
don't
when
let them on time either.
when I arrived here today, I was a little taken aback because I thought we were down to 2 items, and then 2 became 10. So it seems that more time is needed in order to work this out.
Yeah, but they still gotta get a decision sooner than later, so. I mean,
Correct.
What's wrong with the 27th? Is that bad for people?
I'm just letting you know that we will be here 3 days that week if that's, we will be here Amoresco and then Wednesday with the other 2 that I mentioned, and then we could do the 27th.
So we're here on the 25th?
We're here on
No.
the 25th because Amoresco is Chiquita Canyon. And then on the 26th, we have 2, City of Fontana and LA Department of Water and Power. So,
Are the parties available on the 27th? It's a Thursday.
I'll be traveling that day, Your Honor, so it'd be, I guess, depending on time, it'd be very difficult for me to do it.
okay, and the 20th is too soon? That's the preceding Thursday.
I think that might be a little too soon, and I
Okay.
hate to say that I'll be traveling. on that.
Okay, so then either we do Thursday, the 27th, or
July 2nd?
July 2nd.
Looks good for me, the 2nd.
I'm okay with the 2nd.
Would a remote from council be all right on the 2nd, or would we need?
It's worked before.
Yeah,
I
it's
don't-
worked. Yeah.
And one of you can be here. I mean, there's both of you gonna be out?
Both of us. I don't know if Miss Neal will be out, but we will make it work one or the other. But if I need to come down, I will. I'll be in Lake Tahoe, but I will come down if I need to. And if we can do it remotely, then I will.
Perfect.
Go
Up
to Lake
you,
Tahoe.
But we could do.
We get happy to have everyone
We
up
got
there.
Lake Tahoe. So what are you talking about? July 2nd as opposed? to-
July 2nd. How's the district July 2nd?
I won't be available July 2nd. I'm on vacation that time too. So
I'm available, so if that's the date that the hearing board
Yeah.
would like, we
Perfect.
can make that.
Okay, so are we good to go on the 2nd then?
Yes.
All right.
Just so I'm clear, what the next step? We are going to, are we, the board, doing a revised finding and decision order based on the proposed conditions and then submitting it to the parties to look at, and then
And we will
them-
also have a schematic, not a rendering, a schematic from Baker to show us what drainage system is going to go into that pit.
So suppose I will try and make revised findings, and I'll pass it to the clerk to get the input from the 2 of you,
Okay.
but before verbalize
Sure.
it.
Okay.
And it sounds like the only issue is the storage overnight is what we're hearing. And so let us know if your clients bring something else up, but let's try and see if we can work everything out and just work on that one issue.
If I may add, I know, and I was trying to find it in the staff report on 415. One of the facilities was spraying something on it to mitigate, there's sort of a mitigation in the interim, so if there's material going to store, I forget what I can't find it right now, but but there was something in the staff report. I think the Florida facility used ozone treatment, but there was another facility that was spraying some, and it apparently was quite effective in cutting down the odor.
We will certainly discuss all options. I know that all this material is intended for edible rendering, so.
Right, but the material is the same though. I mean, not talking about rendering, it's really about the storage of the material and cutting down, not from the presses and so forth. It's not there. It was in the receiving area. If I find it, I will pass it along to Mr. Pearman too.
Thank you.
Okay. So anything else?
Ask the doctor.
No, ma'am.
Dr. Abraham, are you there? He may have left. That he's still on?
I don't know how to.
Contact him. Yeah. So, okay, well, Okay, he's just, let me see what he said here. Yes,
Cynthia, I can hear you, but I can't unmute.
okay. All right, so we're looking at the 2nd of July.
No, I saw that date. That's fine.
Okay, great. All right.
Yeah, I don't know why I'm not able to unmute on Zoom.
Oh, yeah,
The world of technology. Okay. All right,
All right.
JJ, we'll talk to you later. Thank you.
Yep.
Okay, so then we will recess until July 2nd, when we'll have a new, let's see. Yeah,
yeah.
yes,
Yeah.
Yeah. Okay, and so, and you will have the spec, right? Anything else?
Just one language. I know I proposed this at the last order and it's a free drop. And it was the only thing I could think of, free board. And I like to change it to free drop,
Okay.
and I will pass that along to Mr. Pearman.
The new findings and decisions.
Free board is more for decreases, so, but that's
Sounds
the only thing I could
good.
think of at the time.
Okay, all right. If there's nothing else, then we are in recess.
Thank you.
Thank you
Thank you.
very much, everybody.
Thank you all.
All right.
Okay. That being said, and the only thing I have to state is that in regards to public comments, this section is intended to provide members of the public with the opportunity to comment on any subject within the jurisdiction of the hearing board other than today's item, and speakers would be limited to 3 minutes. Do you have anybody with their hand raised, Madam Clerk?
There are no members of the public with their hands raised on Zoom. And it appears that there's no members of the public in person, Madam Chair.
Thank you very much. With that, we are adjourned. Thank you very, everybody for attending to all your comments.
Thank you very much.
Oh, I guess I should have turned it on, huh?